I think so, probably. Right, good morning everyone. We'll resume the hearing of the applications from Dunedin City Council for the proposed Smooth Hill Landfill in Dunedin. So just before I hand it back over to the applicant, just from the 42A reporting team, anything for us this morning? No? And Mr. Page, thank you very much for agreeing to present your case to us this afternoon. That's very helpful in terms of the schedule that's moving a bit quicker than we anticipated, so thank you for that. Appreciate that. So Mr. Garbutt, back over to you.
Oh, good morning, Commissioners. Good morning, everybody. So we have 4 remaining witnesses. Just for your information, the order we plan to work through them is go back to Sam Webb on Geotech, then Rhys Gervin, Samantha King, and finally Morris Dale. So with that in mind, I'll call Sam Webb, who hopefully is online and available.
Good morning.
Good morning, Ms. Webb. Can you hear me okay?
I can hear you, yes, thank you.
You've just come up on screen so we can hear and see you. Thank you. Good morning. And the Commissioners will have questions for you, but is there anything within your area of expertise that you read from the submitters that you feel you should respond to? And if so, can you do that now, please?
No, I have nothing to add.
No, thank you. Can you just answer the Commissioners' questions?
Yes, good morning, Ms. Webb. I'll just see if we have questions for you. Any questions for Ms. Webb? No? Jan, any questions for Ms. Webb?
I've just got a couple. First of all, I wonder if you would mind just responding to some criticisms that Mr. Iyer has made about your testing for the addition of lime to the loose.
So the addition of lime to the loess is loess has a particular behaviour that is called dispersivity. You add lime to the loess to get rid of that dispersivity, so it reinstates some chemical bonds between the soil particles so that the material is no longer dispersive. We have done some studies to show that the addition of lime assists with that dispersivity. One of the challenges of adding lime is it slightly can change the behaviour of the loess itself from what is loess can be described as having a plastic behaviour, so it behaves a bit like plasticine. When you mould it, it's got a plastic behaviour. When you add that lime, you can get it can change that plasticity behaviour, and we've identified that in our initial studies, we looked at the addition of lime and we did some further testing on the plasticity of the lime, and it was inconclusive. I think the LERS still, we have demonstrated that the LERS can be used, the stabilised LERS can remove the dispersive nature of that material, and we have to check with further testing what its effect is on the plasticity of the material.
And so when do you think that you'll be doing that? Is it part of your detailed design stage, or what?
That will be carried out as part of detailed design in the overall liner design phase. We have enough, the work we've done to date is sufficient to tell us that we can manage the dispersivity of the lime material, of the LERS material by the addition of lime.
Okay, my next question relates to your paragraph 123. Oh.
Ooh.
Just gone a bit dark at our end, so sorry, but now we're back. Here we are. So what you've said here at the start is this quantum of movement is within the tolerable range of slope movement, and I just wanted to explore with you briefly what tolerable range means. We're in a situation with the assessments that we have before us of quite a bit of detailed assessments still to come, and I was raising with some witnesses yesterday a slightly unusual approach in not having completed, for example, a lot of the seismic work that normally is done pre-lodgement. So what, in your view, is a tolerable range of slope movement? Just to assist me with the assessment of that.
The term tolerable in this case is that it is less than, there is no definition of what tolerable is. It is a judgment on the level of movement that we see in the model. We have to balance that that is a model based on the assumptions that we have to do and the limitations of the model, and that that quantum of movement that we're seeing, which at the 50th percentile range is in 1 to 2 millimetres for the failure along the base of the earth embankment, that 1 to 2 millimetres is a very small number, and within the tolerable range, within the modelling, sorry, the word is eluding me at the moment. Within the sensitivity range of the model, if it had been greater, if it had been 100 millimetres, that would have raised concerns that that was likely to be expressed as real movement. Where we see 1 to 2 millimetres of movement, that could be an artifice of the modelling. It is a very small level of movement.
Okay. That's all I had for you. Thank you very much.
Thank you.
So Ms Webb, back in the dark ages when I did my engineering degree, Loess was described as windblown dust and dirt, and it was considered to be an unstable in situ material.
Yep.
So when I read your evidence, it just did make me question in my own mind, given the inherent nature of Loess and the inconclusive nature of your testing, which you've just again highlighted to us verbally, and given the importance of having a liner that does its job for a very long period of time, whether or not as a precautionary measure the use of Loess in the liner should be precluded. Do you have a response to that?
I do. I think it is premature to exclude LERS as a liner material. I think we all did LERS studies on the Yellow River in China, where it was indeed had a reputation of being a very unstable material. We're not suggesting that the LERS is used in its in situ state. So we would remove all the loess because it is not suitable in its in situ state, and that there is lots of uses of loess, successful uses of loess, when you restabilise it with the addition of either lime or bentonite to return it to an improved stability material. The key to the loess, the successful use of the loess, is managing this dispersive nature of the loess, and we've demonstrated through the addition of lime that we can control that dispersivity.
So just in terms of how that would work on the ground, are you able to describe, say if a layperson was to observe the removal of the low S and it being treated with lime, and what would that look like on the ground? Is it removed and stockpiled and then put through some machine, or how does it work?
So typically when you are stabilising soils, there are two methods. You can do it during the actual placement, so you would excavate all of that material from the areas that you don't want it and stockpile it in another place on site in a stable in a controlled stockpiled area. You can then either place that material and add the stabiliser to the material in situ using rotivating machines, or you can actually batch process that material using something like a pug mill, where they actually, looks a bit like a big container with a big rotivating coil in it, and you actually add the material, and then you add the loess material, and then you add the additive. In this case, it would probably be lime, but it could be bentonite, and you get a far better quality control in that way, because you're sort of dosing the soil to a controlled. It's done by volume, so you put X volume of loess in the soil, you put X volume of the stabiliser into the mill, and you churn it, a bit like a Kenwood chef mixer. And so you actually get a very uniform product that is repeatable, and then you use that material to place as the liner material. So there are two methods that can be for stabilisation.
Thank you for that. And in terms of that, is one method preferable to the other, or both equally preferable?
I think they both have their role in different environments. My experience for bentonite enhanced materials in a landfill, I have used the pug mill method, because you have a higher level of quality control of the dosing of the additive that you're using to stabilise the material.
Okay, thank you. So now Mr. Kirk, we discussed issues of the liner with him yesterday, and he's going to do some further work for us. I think it was Mr. Kirk, in terms of coming up with a condition that specifies the type of liner to be used, and then sets out a process if consents are granted should the consent holder wish to use an alternative liner. So as part of that, do you think it would be prudent to specify in conditions the sorts of treatments you've been describing if low S is to be used in a general nature, just to provide certainty?
I think you could, the condition would need to be such that you are generic in that, because we haven't identified yet whether we want to stabilise with lime or with bentonite.
Yep.
So I think a condition would be about what the intent of the stabilisation is trying to achieve, rather than being very specific that says you must stabilise the loess with 2.5, 3.5% lime. I think you have to, the wording would be such that that it would require the demonstration of the management of dispersivity by whatever means, whether that be stabilisation with bentonite or stabilisation with loess.
Yep. Would you be able to assist us put pen to paper in that regard and just feed that through to Mr. Kirk and Mr. Dale, who'll be doing some further work on conditions for us to consider, and that would be
Certainly, yeah.
helpful. And in that regard, given that you have to do further testing, would there be a testing result or a threshold that would make you as a geotech expert think, okay, we shouldn't be using low S? Is there like a tipping point that might result from your further testing?
I think there would be, when we stabilise the LERS and we test the LERS, so once we stabilise the LERS, we would then do further testing on permeability, which is a key criteria for the liner behaviour, and the plastic criteria. And if we saw that the stabilisation had an adverse effect on either of those two properties, that would be the point where we would start to say, actually, the LERS is not suitable for use as a liner.
All right. And just to further assist us, could you also think about, or could you put pen to paper in that regard? And that could be fed into the further work that Mr. Kirk and Mr. Dale are doing also.
Certainly, yeah.
Yeah, just by way of them providing a safeguard, given there are concerns about the low S, and we wouldn't want to preclude its use if it is appropriate, but if at some point it becomes inappropriate, it'd be nice to have that clear for everyone who's administering the consents.
Certainly, yeah.
Yep, no, thanks very much, appreciate that, look forward to that further bit of work, and thank you for your assistance and your evidence.
Thank you.
Thank you, Ms. Webb. So the next witness then will be Mr. Gervin.
Morning.
Yes, good morning, Mr. Gervin. Michael Garbutt here. We can hear you and you've come up on screen so we can see you now. Just test your audio, please, and introduce yourself.
Morning. Hello, yeah, Reece Given, the landscape architect.
Yes, thank you, Mr. Gervin. And similar to the other witnesses, was there anything within your area of expertise that you felt you needed to respond to the submitter's evidence on that you read?
No, there was nothing further. Yeah, thank you.
No, thank you very much. Can you answer the Commissioner's questions? Thanks.
Yes, happy to.
Yeah, good morning, Mr. Gervin. I'll just see if we have questions for you. Jan, any questions for the landscape expert?
I've got a couple of questions that do come out of the evidence for the submitters, but I'm sorry at the moment I can't quite remember who it is, so just bear with me. Somebody said in this volume of material I have on my desk, I think, that the growth rates of kahikatea are slow and that other options should be looked at. And the second point made by somebody was that the intended Kanuka planting is a fire risk and should be replaced with another option. So could you just respond to those two things, please?
Yes, so the first question, growth rates of kahikatea, it's Kanuka that we're growing. So we don't have kahikatea as part of the mix, it's a Kanuka total mix. And I guess this responds to the second question as well. So the kahikatea is where we're planting, the Kanuka, we're planting around the existing forestry. So it is a fast-growing species and it will grow in that context. The second question about the use of Kanuka as a fire risk species, we have looked at that, and where the planting is proposed between the landfill and Big Stone Road, we've replaced where we were previously planting Kanuka with low flammability species that will provide the screening necessary. So in terms of the planting, Kanuka isn't proposed adjoining the landfill in that location. So I think that answers both your questions. So we're not planting kahikatea. Kanuka is not proposed adjacent to the landfill as part of managing that flammability issue.
So have you got a landscape plan that shows that? Or like, is there any
Yes.
revised plan, and
Yes.
when are we going to see that then?
So in figure 1, RG1 attached to the end of my evidence, we've got, so that's got
That's showing that?
Yes, so it's got the low flammability screen planting, and you can see that we've coloured that in pinky colour. So that's along this between Big Stone Road and the landfill. And we've got if you go to the top left-hand corner of that, you can see where that the cross-section of where that is. And we've got the species that we're using there, and those cross-sections, underneath both those cross-sections, you can see a little asterisk, and it lists out the species that we've used there.
Okay.
And those species have been selected from the low flammability guidance provided by the New Zealand Fire Department.
And what's their growth rate like?
So they're pretty, they're kind of fast-growing sort of shrub, small trees. So they'll probably, after about 10 years, they'll get to about 4 or 5 metres, and about 15 years, 6 metres is pretty, at least would be their height. So yeah, the way that works, just to clarify that, there's the first row next to Big Stone Road is pine, so that'll grow quite rapidly, and then that'll take up 5 metres. Beyond that is where the fast-growing natives will be planted, so the low flammability natives. And so the idea is that when the pine needs to be limbed up or removed in the future, you've got that screening established beyond the pine.
Okay. Thank you. That's all the questions I had for you.
Morena, I have one question for you. At paragraph 35 of your evidence,
Yes. Yes.
Where you're addressing visual effects, it follows on from the conversations around the pine. So you've stated that the fast-growing pine shelter belt will provide for a more rapid visual screen. What do you mean when you refer to rapid?
I guess in terms of one of the reasons we're using pine there is that it will grow quite quickly, and you can see that on site. Yes. So in that paragraph, I've given the anticipated growth rates that you'll get, 2 to 3 metres in 3 or 4 years quite easily from that. So I guess that's what we're saying, where it will be a fast-growing screen vegetation. So I've given some timeframes in terms of the growth rates there. So in about 3 to 4 years, you'll get 3 metres out of that.
Sure, and so we saw that actually on site. So the existing pine shelter belt there, how old were the species, those pines that were there already? Because they looked like a reasonable height.
Yeah, exactly. Yeah, so I'm not sure the exact date that they were planted, but they were there when I was on site about 2-3 years ago. So they're probably there. I'll probably defer to others, but they've been
sure.
They're quite rapidly growing, I think, is the point.
Okay. And so in terms of your assessment of the temporary and localised effects of that, you've stated that there would be an initial temporary moderate to low adverse effect on that property in particular. So when you say moderate to low, what that category, does that align with minor, less than minor, in terms of the effects hierarchy? Or what do you mean when you say moderate?
Yeah, so I guess in terms of best practice from landscape effects, we have a 7-point scale, and moderate, so I guess from very low to very high. So in terms of looking at that scale, it's sitting in the moderate low is in the lower part of that scale. If you align that to RMA terminology, it would be minor effect, I guess, in terms of how that scale works. I think the key thing there to take into account is the duration of effect is one of the things that we're managing there. So we're growing rapidly growing species, which we can see on site. That's what will happen to reduce the extent of use, or the duration of use, and therefore any views that are enabled will quickly be concealed by the planting proposed. So moderate low is given that is if you put it in RMA terminology, a minor effect.
Great. Oh, thanks very much. That's really helpful. Thank you. That's all I have.
So Mr. Girvan, just looking at your RG1 that you referred to earlier, my understanding of that, looking at the left-hand corner of that, where you have the pictures of the planting,
Yes.
is that the planting is inside the designation boundary?
Correct, yes. You can see that the site boundary is on, if you're looking at those cross sections, the dashed red line to the right.
Good, that's what I thought. Just wanted to confirm that. And also looking at that diagram, if you got it in front of you?
I do, yes,
Yep.
yes.
And so you see within the designated site, there's a thing called Eastern Earth Stockpile Area, that grey rectangle.
Yes,
Yeah, and then just above that, the designation boundary, I couldn't see from the diagram, does the screen planting extend down that boundary that's got the tag limit of designation attached to it? Does the
no, the screen planting is along the road boundary. So,
road boundary only?
yeah.
Yep.
Yep. And you can see it does extend along the central, there's a sort of a spur through the site, which you would have seen. So it does extend along that spur as well, which is, to the left of the eastern earth stockpile, but not along the boundary, you're saying.
No, thank you for that. I mean, the site's designated, so it doesn't require further land use controls under the district plan, but I was just curious regarding the extent of the landscaping proposed. So, no, thank you for clarifying that. That's no further questions.
Cool, thank you.
Oh, thank you, Mr. Girvin. You're free to go, thanks.
Thank you.
And the next witness then should be Ms. King.
Good morning.
Good morning, Ms. King. I take it you can hear me okay?
Yes.
Good, we'll just wait for you to come up on screen here. Good morning, we can see you and we can hear you fine. Good morning, welcome. And just in terms of your area of expertise, I don't understand there was anything that you wanted to respond to, is there? Or if there is, can you do so now in terms of submitters evidence?
Yes, I just wanted to respond to Mr. Hutchins' submission from Otokea Creek Marsh Habitat Trust.
Thank you.
Mr. Hutchins raised concerns regarding the requirement for intensive and landscape scale predator control, and while I agree that landscape predator control is necessary and will benefit biodiversity at a wider scale, I believe that any translocated southern grass skink would probably be benefited by two means of protection at that site. One of those would be predator control as a cover to reduce effects from translocation, and the other would be protective habitat enhancement, such as like more complex plant species planted at that release site that would provide more refugia for the southern grass skink. And I just wanted to clarify that Mr. Hutchins' submission described predator control requirements for a larger bodied species of skink that is not so receptive to protective habitat enhancement that a smaller bodied and faster reproducing skink like southern grass skink is.
Okay, thank you. Can you answer other questions, please?
Good morning, Ms. King. I'll just see if we have questions for you, Jan. Any questions?
Nothing from me, thank you.
Morena, Ms. King. I have a few questions for you, mostly raised through submissions and just to check my own understanding of your assessment. So I'll just talk you through those now. You've mentioned that you've done some surveys in March 2020 and May 2021, and in your opinion, the likely presence of Indigenous skinks, but the exact species are not identified. So I guess I'm curious in terms of how certain can you be that there's not a presence of Indigenous skinks within the landfill itself?
Yeah, so I guess the answer to that is that the species of skink that would most likely be on site are usually more confined to those rank grass habitats, so the ones that we find around the road margins and things like that, and also confined to the Indigenous vegetation in the West Gully areas of the designation site. But within the wider landfill site itself, the habitat quality there is basically being afforested, so the lizard species, any lizards there would likely either move out or not be present, just because that habitat keeps changing quite frequently over time.
Sure, so it's unlikely,
Yes.
basically, is your conclusion there.
Yeah.
And also I'm interested in where you've said that it's impractical to consider salvage for only one or two individuals where there can be greater benefit gained through other measures. Could you talk me through that in terms of why would that be impractical?
Basically, the methods that we have for capturing lizards are quite constrained, and they basically there could be it could be difficult to capture lizards if there are only one or two, because trapping would be required over a significant period of time to try and capture one or two animals, especially over such a large area. And basically that's why we've kind of designed it to have these tracking tunnels where if we find that there are lizard species present through those tracking tunnel monitoring, we'll put traps there and capture any lizards if we get enough prints in that area. Otherwise it would be too time consuming and it would be too costly, whereas that money could be better transferred into habitat enhancement in those areas that probably would benefit greater from it.
Great, thank you. That's really clear. Thank you. And lastly, you may have covered this already in your evidence, but any concerns or effect of the relocation of the individuals if they're salvaged and translocated, in terms of them being able to settle into the new habitat areas?
Yeah, so I guess that's where we provide that extra habitat. So we've got a habitat buffer, and we would also do a cover of predator control. So the predator control would, it basically reduces any of those immediate impacts on the species, such as displacement or any of that disturbance, and gets them to settle into the environment a lot quicker.
Great, thank you. That's really helpful. That's all I have.
So Ms. King, I just want to ask you about the proposed road widening and realignment works, which are the only aspect of the proposal that require further land use consents under the district plan, given the site's designated. I asked Mr. Whaley yesterday, given the narrowing of the road widening works in certain areas to avoid wetlands, whether or not the works now proposed would impact on lizard habitat and the rank grass, etc., on the roadside margins. Can you answer that? And he deferred to you. So, will the proposed road widening works in their current state impact on significant lizard habitat?
They'll still have the same effect that they would in the original proposal.
And can you just summarise that effect for us briefly?
So that would just be the reduction and loss of rank grass habitat along that road margin.
And how would you categorise that on an RMA effect scale?
I would consider that to be minor or less than minor.
Yeah. Just looking at that activity in isolation, so putting aside in your mind whatever might happen within the larger designated site, would those roadside works of their own, just in a standalone basis, require a lizard management plan in your experience?
Yes, definitely.
Okay. And in terms of the biodiversity enhancement works that are still being offered by the applicant, probably on an OSIA basis, wetland enhancement and revegetation, I think it is, of the West Gully, do any of those biodiversity enhancement works have an adverse impact on lizards or lizard habitat?
They shouldn't have, no.
Okay. And briefly, the reason for that is?
I think the benefits to the biodiversity would outweigh any adverse effects, such as habitat disturbance or anything like that.
All right, that's all I had for you. Thanks very much for your evidence and for answering our questions this morning.
Thank you.
Thank you very much, Ms. King. Right, so that brings us to the final witness, Mr. Dale. Good morning, Mr Dale.
Good morning.
Now you this morning provided to us as council an updated version of your evidence with some minor corrections that we provided to the hearing administrator and asked that they be provided to the commissioners. I don't know whether that's found its way to you commissioners, but Mr Dale, can you please explain to the commissioners what you've provided in terms of corrections to your evidence?
Certainly. Yes, sorry, there were just a few minor corrections I needed to make to my evidence. My apologies for those. If I just turn your attention to paragraph 20 and 21 of my executive summary. I'd just like to have those two paragraphs struck through. They were a repeat of a section later in my evidence and don't need to be there. Paragraph 39. In the first sentence, there is a reference to water level loggers. Just delete that as well, please. Paragraph 107. 107A, reference to contrary should be replaced with inconsistent with. Paragraph 134. First sentence, the reference to inconsistent should be replaced with contrary or inconsistent with. And finally, in paragraph 157, the reference to the wording which says it is unclear whether a coherent environmental outcome is completely provided for and the consent sought should be replaced with it is unclear whether a coherent environmental outcome is completely provided for in the planning documents for the consents sought. Thank you.
Yeah, good. Thank you for that.
And can you just comment to the commissioners whether with those changes it changes any conclusions or any other assessment you've provided in your evidence?
No, it makes no changes.
Okay, thank you. Are there matters of a planning nature within your expertise that you've read from other submitters since you filed your evidence that you want to comment on to the commissioners?
Nothing specifically. I can make brief comments in relation to the matters raised or discussed on conditions yesterday, if that would be helpful. Yeah. Otherwise, happy to just take questions.
Thank you. Okay, can you do that?
Yep, so we'll just go to questions.
Yes, thank you very much.
Questions.
Good morning, Mr Dale.
Morning.
I have some questions around your effects assessments, and a key issue to arise is the effects of landfill on aviation safety. So in your evidence, you're talking about the fact that the measures described by the experts in your team will greatly reduce the risk of landfill attracting birds and therefore avoidance of any risk to aviation safety. But there's clearly quite a difference of opinion between the airport submitter and also some concerns in other submissions and with the Section 42A report. So I thought it would be useful, please, if you could just talk through how you've arrived at that opinion and how that differs from the other points of view.
Yeah, certainly. I think probably where the difference lies is how each party or witness has interpreted Mr Shaw's evidence. The way that I have interpreted Mr Shaw's evidence is that the measures that he has recommended and have been adopted in the draft conditions will ensure that there is no increase in aviation bird strike risk, and therefore any adverse environmental effects as a result will be avoided, is where I have got to.
Sure, so no increase from the existing, excuse me,
Correct, yes.
status quo, and therefore that in your mind equates to the avoidance of?
Yes.
Yeah. Okay,
Yeah.
thank you. In terms of your policy assessment, again, there's some difference in opinion in terms of the Section 42A author and also Mr Bonus for the airport arrive at the conclusion that the proposal is contrary to key policies in the partially operative RPS. And I'm interested, again, if you could talk me through how you arrived at your opinion there and the weight that you've accorded to those provisions in your overall assessment.
Yeah, in terms of the issue of weight, I have given a high degree of weighting to the partially operative RPS, given that all relevant provisions are beyond challenge. In terms of the proposed RPS, those provisions are subject to extensive submissions, both for and in opposition. I have given relatively limited weight to those provisions as a result. I think, again, where the differences lie between myself and, for example, Mr Bonus and Miss Lennox, again, relate to how we have each interpreted the evidence, particularly that of Mr Shaw. And as I said earlier, my view on the basis of that evidence is that the effects will be avoided, and as a result of that, when looking at the relevant policies, particularly those of the proposed, the partially operative RPS, I consider it will be consistent with those provisions.
Okay, thank you. Just going into a little bit more detail around policy 435, I think if I've remembered correctly, that's around the, the effective functioning of significant infrastructure, I think, from memory. There's a clause in there around reverse sensitivity, and I'm just interested in how you would describe reverse sensitivity effects in this context and whether that clause is applicable to this situation.
Yes, so the relevant clause A talks about restricting the establishment of activities that may result in reverse sensitivity effects. Reverse sensitivity, in my mind, is where you have a more sensitive activity establishing in close or in proximity to another activity which may result in constraints on that existing activity occurring. Firstly, I'd say that a landfill is probably not a particularly sensitive activity in the context of an airport. However, I also acknowledge that as a consequence of establishing a landfill and the potential attractive that may present for birds, that has the potential to then have a consequential effect on the operation of the airport, which on the basis of my evidence I think has been addressed.
Certainly, so perhaps not, more indirect reverse sensitivity effect, is that what you're saying? Or so it's applicable but it's...
Potentially applicable, yes, but not perhaps in the more common way that reverse sensitivity would be applied.
Sure, thank you. I think that's all for me. Thank you very much.
Thank you.
Okay. Jen, question?
Yes, thank you. I'll just pick up on that last point because it sort of rolls into one of my questions, and this is relating to paragraphs 117 to 120 of your evidence. And in here you're talking about the functional need for a landfill in this location.
Yes.
And you're referring also to the proposed RPS and the NPS fresh water and so on. I just want to explore with you why you consider this landfill has a functional need to locate here.
I think, firstly, I'd just turn on that particular definition of functional need, which is referenced in both the MPS freshwater and proposed RPS, and that talks about the need for an activity to locate in a particular environment because the activity can only occur in that environment. So that's not, I read that as not requiring an evaluation of different sites, but rather an evaluation of, when you look at this site, is there a need for this activity to establish in a wetland or river environment in the context of those relevant policies.
Okay.
Does that assist?
Yep, let me just write that down.
Okay.
Sorry. And just following on from the questions you just had about adverse effects on birds, I think your answer in terms of saying the planners are all interpreting perhaps the evidence differently may have some merit. I'm not sure you're all that far apart. You're all reaching different conclusions though.
Yes.
And you would have heard us yesterday, I think you were here all day yesterday, weren't you?
Yes, I was.
Asking Mr. Shaw about his methodologies and how confident he was that this was all going to come to pass and there would be no problem. So if, for example, one of those methodologies doesn't actually work out as well as he might think or consider, then do you agree that there may be some potential for an increase in aviation safety?
I mean, I'm very reliant on Mr. Shaw in that respect, but if there were to be an increase in aviation risk, I think the conditions provide a process whereby those management actions can be reviewed, they can be updated to address any issue that might result.
I think what the airport are likely to say to that this afternoon is something like, we don't really have time for that, because if we have a problem, we have a problem today.
Yes.
And Mr. Page's legal submissions allude to some of those thoughts. So what's your response to that sort of line?
I certainly acknowledge the need for, if an issue arises, that there needs to be urgency around that, and to ensure that there isn't any increase in aviation bird strike risk. Whether the conditions are sufficient as they currently are worded to address that, I think is something that we can certainly explore further. Mr. Bonis's evidence in particular raises some matters around how conditions could be improved to address those concerns, and I'm certainly happy to explore those as part of the redrafting exercise that I've been asked to do.
Okay, so you're just going to do that in one big package.
Yes.
Let's turn then to the conditions, and the first question I have around this is in your paragraph, whatever it is, quite early on, 3, you tell us what your experience is, and you do mention sort of being involved in large-scale construction activity and that sort of thing, but you haven't mentioned landfills. Have you ever consented a landfill before?
No, I have not. This is my first.
First time. So I'm interested to know where you started with the conditions. Did you actually read other consent conditions?
I certainly did, and my starting point was the Cape Valley consent conditions, because it was one that I was familiar with. It was reasonably recent, and I guess perhaps comparable to what was being proposed at Smooth Hill in terms of maybe not scale, but the types of waste accepted, etc.
Okay. And the Chair has given you now a rather fulsome set of comments on structure and so on that I don't know if you've had time to work your way through yet.
No, you wouldn't have.
No, because they only came through quite late last night, I think.
This morning.
So there will be some comment in there and that we have discussed between us about the way that landfill consents are commonly structured. And so we'll leave you to reflect on that. But I've got some particular comments I just want to add to that, if you don't mind. Just
Sure.
There's only a few conditions, but I'll do it now so that you can do this in one big wrap, if that's okay.
Certainly.
So if you just find the conditions. So I'm just referring to the ones that were on the back of your evidence that I think Rob has now sort of saved your changes and so on and put comments on the top, but I'm just referring to the hard copy you had, okay? So the first one's condition 2, which was the review condition, and I was just wanting to know why you had deleted the, what was A there, dealing with any adverse effect on the environment which may arise from the exercise of this consent. Sometimes that's in a review condition and sometimes it's not, but I just was wondering why you'd actually taken it out.
Simply because it's captured within the revised wording of the new 2A. So it was essentially a repeat.
Oh, right, okay.
Yep.
Okay. Number 12. So I'm just going to go through these pretty quickly because I think this is all going to get overtaken by a whole lot of other things. And this is one of those where I raised yesterday the need, I think, to specify liner design in the conditions. Mr. Coombe was looking for a bit of flexibility around that. All of the different conditions have different prescriptions on them, but it's quite difficult to get that one right, especially if you want a little bit of flexibility. 43. So I haven't had time myself to go through and check what I was going to ask you versus the new version. So this is where I raised the question of limiting the tip face or open working face area, so just to alert you to that.
Yes.
My view of that is that you don't just need that for landfill fire risk, but you need it for odour management. I know that we're talking about no putrescible waste and so on, but I see no harm in that going in there for the same reason. It should be a general condition.
Understood.
77. The point I have scribbled here in my own notes is, this is under bird management, but it actually obviously overlaps with waste acceptance. And some of the submitters have been quite critical about the waste acceptance conditions and how that's been approached. And so I think you need to give some thought to the overlap between those two things. Again, waste acceptance criteria and any consent conditions I've ever seen are always very specific. So there can be no doubt about what's coming in and what's staying out.
Yes.
Some of this is really not aligning very well. So it needs to be rethought, okay?
Thank you.
I'm just going to skip through these quite quickly because some of this has now been overtaken by something else. Condition 79, I did talk yesterday a little bit about this with Mr. Shaw, not the conditions so much, but just the practicality about, who's going to do all of this bird registering, where's this register going to be kept, who's it going to be given to. My observations on sites have been that it seems very unlikely that typical landfill staff would be doing this sort of thing because they're a bit busy doing other things. So you might want to just think about whether that needs to be fleshed out a little bit so it's clear as to how that's going to all work.
Yes.
Because his methodologies are very interesting, but they actually need to also be very clear so there can be no debate about what's being done and why. Yes, now your waste acceptance is on page 29 of your conditions and it starts at condition 89. So a lot of those conditions typically come into things like a general condition, but they might also come into something like, I think the comments that Rob has made also relate to attaching your conditions to the consent that you're actually obtaining. So if you've got
Yes.
a discharge of solid waste to land consent, you might have it in there.
Yeah, understood. Yep.
It's just all floating around a bit and
Yep.
not really landing anywhere, okay?
Yep.
And then I thought through your section on landfill fire prevention and response, there were quite a few of these conditions that were also somewhere else, and Rob may have already made that point, but they're a bit repetitive, so they need to be rethought. And that's the point of a lot of this stuff comes in a general condition, so it's just said once. And the general conditions then apply to all of the various consents. And lastly, I'll just have a quick check of this one. This is a very long one here. What's this? 113, I think. Oh, the landfill management plan. Yeah, I won't take you through that because I know there's going to be a whole recast of following from the comments. So just for the benefit of submitters who may be watching online somewhere, I do want to just stress again, I as the chair had done yesterday, that the questions we're asking on conditions are not because we have made up our minds and have determined to grant consent. It's because we have the applicant before us. We have to explore these matters now while they're here, and to also give the submitters a chance to respond to the points and the answers. So just to be clear on that, doesn't mean anything in terms of a final determination being made, but we just want to be clear on what the applicant's position is, and if consent was to be granted, then obviously the conditions need to be very clear and enforceable, and that's what we're raising with you. So that's all I had for you. Thank you.
Thank you.
Mr. I just want to explore a couple of things with you. You do have my massive list of comments on the conditions, so you look forward to working through that, I'm sure. But in terms of the proposed regional policy statement, I think I generally agree with you in terms of the weighting that should be given to it. It's statutorily immature. It's also subject to High Court proceedings regarding whether or not it's a freshwater instrument, and
Yes.
that decision isn't due out any time before June as far as I'm aware. So I think we're reasonably on the same page regarding weighting on that. The only exception might be if the proposed regional policy statement was to contain within it a significantly or radically different policy outcome compared to the existing statutory instruments. And an example of that would be reflected in the evidence of Edward Allison from Te Runanga, where he's saying Te Mana o Tuwai is now greatly expanded and dealt with in the proposed RPS as compared to the previous statements. Are there any other elements of the proposed regional policy statement that fall into that category, where they direct decision makers to go down a quite different track compared to the status quo instruments?
Certainly, as you say, in regard to freshwater, I think they do. It's quite a different policy regime within the proposed RPS to give effect to the NPS freshwater. In terms of other aspects, what I would say is that in a general sense, my reading of the proposed RPS is that the provisions are typically more directive. They're more extensive than the equivalent ones in the partially operative RPS. I think there is a greater use of avoidance protection type terminology. It's hard to sort of pinpoint any specific examples without sort of going through my policy analysis bit by bit, but yeah, that would be my general comment.
So just reflecting on that in terms of the matters before us, it would be the proposed RPS provisions regarding the Te Mana o Tuwai that would be predominantly in that category of a different direction then,
Correct.
apart from other more directive policies on matters that are already covered in the existing instruments.
Yeah, I'd agree with that.
Okay.
Yeah.
And so, Ms Lindsay, Ms Lennox, when we hear from you, I'd be appreciated if you could give me your views on that as well, particularly if you have a different point of view. I'm sure Ms Melhoff can help you with that. Just looking at the statutory analysis, the statutory instruments that we have to have regard to, things have moved on a lot, as they do with projects like this, from lodgement and refining the nature of the activity, and that's all well and good, that's quite common. given where we are today, and based on the evidence that we've heard, including the evidence given to us verbally yesterday, where a number of experts agreed that further conditions might be required regarding the liner, etc. Putting all that in the mix in your mind, are there any remaining areas of significant disagreement between yourself and the other qualified planning experts? And those words are used deliberately. The other qualified planning experts we're hearing from, Ms Lindsay, Ms Lennox and Mr Bonus. Putting aside bird strike, I'll come to that in a minute. But are there any significant areas of disagreement between yourselves and the other experts?
I think based on the Section 42A report of Ms Lennox, there was, I think, disagreement around a range of relevant policy matters, not just in relation to bird strike, but also Indigenous biodiversity and freshwater management in particular. I have gone through those aspects in my policy analysis in response to those, and have reached a view that I believe the proposal will be consistent, or in an overall sense consistent with the provisions of the relevant planning documents. In terms of Mr Bonus, obviously there is still some disagreement there in terms of how we have, in terms of the relevant planning provisions, based on how we have interpreted the evidence of Mr Shaw. I think that's where the areas of disagreement still lie, as I understand it.
So just drilling down to that a little bit more, so in terms of Indigenous biodiversity, would that be within what's been called the swamp wetland, just at the toe of the proposed landfill footprint?
Yeah, effects on downstream wetlands in terms of their extent and values, and also effects on freshwater values further downstream within the catchment.
So further down towards Brighton and the estuarine area, marshland down there, or closer?
Closer to the landfill.
Okay.
Yep.
And in terms of freshwater values, what did you have in mind when you mentioned that? What particular values?
Well, I think the evidence or the Section 42A reporting talked about, I guess, there being some residual uncertainty of the hydrological effects on the downstream catchment, and as a consequence, uncertainty as to effects on freshwater values, whether that be fish or other values. So, and based on the evidence for DCC, which I've relied on, I consider those matters have been addressed.
So just briefly turning to that policy 4358, that's been the subject of a little bit of discussion. My understanding of the reverse sensitivity effect is, as you described it, for example, if you might have an existing odorous industry, let's say a mushroom factory, and then residential development encroaches on that, and the odours from the factory cause the residents to complain, which then means that the council leans on the mushroom factory and says you can't operate in this way anymore. That's what I understand reverse sensitivity to be, is that?
Yes, I'd agree with that.
Whereas the effects of the landfill on the airport, they're just run-of-the-mill potential adverse effects?
Yes, I think so.
Okay. Now, just turning to the evidence of Mr Bonus, and at his paragraph 82, he has some quite specific recommendations regarding conditions, albeit not necessarily spelt out in terms of precise wording. Have you had an opportunity to reflect on his recommendations, and if so, what's your view on those?
I have considered those. In terms of his request for relatively minor changes to Condition 2, Condition 7G, and also cross-referencing Condition 43 and Condition 44. So this is at 82.1, 82.2 and 82.3 of his evidence. I'm relatively comfortable with those requests, and would be happy to suggest some wording around those.
Yep, good.
In terms of his point at 82.4, I think that's probably more a matter for, I would need to seek some advice from probably Mr Henderson on that, as to the appropriateness of that, because that relates to the attachment 3 waste separation methodology. And also likewise, the reference he makes at 82.5, I think again relates to that waste separation methodology, which I would require some assistance from Mr Henderson on.
All right, so when you do some further work on the conditions that no doubt you'll be doing, you'll reflect on, well, your role in it is 82.1 through to 82.3 with some suggested wording from your perspective. It'd probably be useful, certainly when you do that, to have dialogue with Mr Bonus, who's also an experienced planner, and the two of you might be able to come up with some suitable wording that deals with those 82.1 through 82.3. As you say, they're quite minor things, it shouldn't be pretty straightforward. And then also, once you talk to Mr Henderson and then you have a position, it'd be helpful, I think, if you discuss that then with Mr Bonus.
Yes.
And I know we're hearing from Mr Bonus this afternoon, and I'm sure he'll be agreeable to that. Mr Bonus has appeared before me a number of times before, and he's a helpful witness, so I don't see any problems in that regard. The other matter is that obviously there will be further work done on conditions, and we've got a lot of the hearing to go yet, so there might be some more issues coming out of the woodwork that we might ask either yourself and or the 42A team to give some thought to. But at some stage you'll be developing an amended suite of conditions which potentially might be structured quite differently. Just like you to give some thought to how you can make our job easier in terms of then relating that to what's currently before us, and depending on the degree of restructuring, that might be quite a difficult task. But so I'm not going to propose a solution, but maybe between yourself and other members of your team and the council officers, you could come up with some kind of system where we can easily see what's new and what's not new.
Yeah, understood.
And it would also be very helpful, and I discussed this yesterday, in terms of the further work to be done on conditions, for you to, if possible, do that in consultation with the council officers. And then with whatever you end up with, and I imagine it probably forming part of a reply, if not before, to clearly indicate areas of residual agreement and disagreement with the council officers in particular. And if there's disagreement on, say if there's agreement in principle but disagreement on precise wording, to put in the options, so wording that you think is appropriate and then wording that the officers feel is appropriate, just to have it there with some kind of colour coding system, so we have before us nice and easy understanding of the different points of view from the qualified planning experts before us.
Happy to do that.
Yeah, that'd be great. And also, as I said yesterday, in terms of the annotated versions of the conditions that I've been forwarded through to Council this morning, I'm not sure if they've been forwarded to you yet. Some of those comments are reasonably cryptic. So if there's anything in terms of my comments that you think I just don't understand what the chair's asking me to look at here, I'm very happy for you to either in a reconvened hearing setting or just by way of email or whatever, just ask for clarification. I think it's important you understand what was in my mind when I wrote some of those comments.
Thank you.
That's all good. All right, let's start with no further questions from us. Thank you.
All right, well, thank you very much. And I've forwarded Mr Morris the document, but only while the hearing's been going on, obviously, so he hasn't seen those. Thank you very much for that. So that concludes the evidence and the case for the council. Obviously, Mr Dale and the other experts are tasked with producing a revised suite of conditions. That's obviously important to the applicant to pursue that work and to provide you an offered set that the applicant agrees to subject itself to, so that you can consider that. I haven't discussed with Mr Dale when that might occur or anything of that nature, but I think he needs to, and we all need to monitor the rest of the hearing and as you've heard him say, gather up and collect all the changes into a suite, and he will need to consult with other relevant technical experts who are doing that work as well. So perhaps at the end of the hearing I just reserve that we discuss the timetable and some procedural arrangements around that once we have a handle on the magnitude of that task.
Yeah, I think in that regard it's best to make haste slowly. So look, if we get to this stage next week where we would normally hear from the reply, if you think, no, you'd like an extra few days or weeks to do some further work and we need to adjourn and come back to hear the reply, that's absolutely fine.
Yeah.
We'd
And
rather
we'll
you put
just,
the effort into making it as good as it can be when we come to look at that.
yeah, and we'll just monitor progress on that, and if I can address you at the conclusion about procedural matters, I'd like to do so. But with that in mind, that concludes the applicant's case, so thank you very much, and we look forward to hearing the other parties' presentations. Thank you.
As do we. So in that regard, we're adjourned for now and reconvene at 1:30. Mr Page, and we'll hear from the airport. And Mr Page, just in that regard, is it your intention to table any supplementary / rebuttal evidence at this stage?
Not table, no. There are some witnesses who wish to respond to some of the things that they've heard, which I'll invite them to do orally.
Yes.
I think Mr Keogh plans to, he's prepared a short summary of his evidence that he will table and read. The other witnesses don't feel the need to do that, but if you would be assisted by them elaborating on things, then I'm sure we can work that out as we go.
Yeah, no, I think the process we've had from the applicant's expert witnesses worked well from our point of view, so happy to take material as read. If Mr Keogh wishes to read a short summary statement, that's also fine. I mean, that's provided for in the minute that I circulated quite some time ago. As with the applicant's case, your witnesses responding verbally to matters that have arisen, that's also good, but as we've asked the applicant to do, if your witnesses could then thereafter document whatever they tell us verbally in response, and that can be provided at some stage that's convenient to yourself, that would also be good.
Yes, thank you. We'll do that.
All right, excellent, and we'll see you back here at 1:30, everyone. Thank you.
Thank you.
G'day, Richard. How are you?
Hello, who am I talking to?
It's Si. How you doing?
Oh, good mate. Oh, Si. Oh, Si. Oh,
Yeah,
good, mate.
that's right, mate. Yeah, I'm good.
You
Yeah,
alright, you
your audio's all good, mate.
good? Okay, thanks, man.
All right.
Cheers.
Cell phone on side?
Yes.
Good afternoon, everyone. We'll resume the hearing for the consent application sought by Dunedin City Council for their proposed Smooth Hill landfill. And just before we hear from our next submitter, which is Dunedin International Airport Limited, I'll just check anything the 42A team needs to draw to our attention at this stage. No? Applicant, anything? No? All right, Mr. Page, good afternoon and welcome. Over to you.
Good afternoon, Mr. Chairman. Thank you. This afternoon you're going to be hearing from me firstly, then Richard Roberts, who you heard of from just a moment ago, unexpectedly, but it was nice to hear his voice. He was to be here, but unfortunately as at 11 a.m. he is now a close contact and in isolation, so that's why he's not with us. But that's life these days. After Richard, the airport's operations manager, Daniel De Bono, sitting next to me, will give evidence. After Dan, you'll hear from Sean Rogers from the Civil Aviation Authority. And then after Sean, Mr. Kieran Keogh, who's sitting next to Dan, will be here to present a summary of his evidence. And then lastly, Matthew Bonis, he is also online and will join us from Christchurch. So that's the order of events. You have my legal submissions. I'm accustomed to your preference not to read those to you. I won't do that. What I will do, I have been making notes during the course of the hearing of things that I think need further submissions on, and so I will address you orally on stuff that has cropped up in the meantime, and answer questions as may be required. So, with that approach in mind, the first and primary submission for Dunedin International Airport Limited, I will just refer to it as DIAL. The first fundamental approach from DIAL is that this project is in the wrong place. And it is in the wrong place because when it was purchased in around 1992 and designated in 1995, we can find no evidence that the aviation hazard to Dunedin Airport was considered or taken into account at all as part of the site selection and designation process. The airport has no record of ever having been consulted during that period or subsequently. So when in his evidence at paragraph 38A, Mr. Henderson said that the Landfill Study Refuse Working Party addressed site selection criteria including bird strike, we have got no idea what that means in reality. If the airport wasn't consulted or contributed and participated in a bird strike hazard study at that time, we do not know who did. And the airport wasn't consulted prior to the decision being taken to proceed with these applications. We have been actively involved working with the council subsequent to the lodging application, and we commend them for the work that they've done since then. And much of the conditions that have changed and been presented through the evidence of Mr. Dale have arisen from working with our team, trying to come up with something that might work. But the fundamental starting point for the airport is that the site is within its airspace that's affected by its designation. It's inconsistent with international and domestic guidance about where a facility of this kind should be, and presents an unacceptable hazard over its lifetime. Now, Part of the problem too is how the landfill is to be managed. In Mr. Henderson's supplementary evidence at his second bullet point and in his evidence in chief, he referred to multiple options for waste disposal being considered during feasibility studies conducted as part of the business case process for Smooth Hill. So that's the second bullet point on the summary sheet that Mr. Henderson handed up. Again, the problem with that from the airport's point of view is that it's completely opaque. We've got no idea what was in the business case. We don't know what its terms of reference were. We don't know what the goal of the business case was. I'm more accustomed to seeing business cases to identify whether a particular project or proposal might generate an economic surplus. Well, that's not really the kind of thing that a business case for a landfill deals with. So why splitting the waste stream for disposal at different sites might have failed the business case analysis is just not known. The only specific reason advanced was that exporting waste out of the district would be unacceptable to mana whenua. But again, we don't have any explanation for why, and from mana whenua's perspective, statutory local government boundaries under the Local Government Act have particular cultural significance. We don't know why it is that waste is being brought to Dunedin from outside of the district without opposition. We don't know why the consent application is not limited to only receiving waste from within the district, if the cultural considerations of that importance. So the reasoning, respectfully, is opaque. And it's Dial's proposition, and I'll come back to this when we look at the drafting of the conditions, that if, in your assessment, a landfill should be consented, the categories of waste which are provided for in the conditions are unacceptable and should be further limited. Particularly the categories of waste described in condition 43 as highly odorous waste, and the category of waste in Appendix 3, which is described as contaminated or special waste. Dial's position is that that must not come to Smooth Hill if Smooth Hill is to be consented. We know that stuff attracts birds. So that outlines what Dial's trying to achieve here. Part of the problem here is that there is an asymmetry between risk and reward. And you can understand what I mean by that when you ask, what if this all goes wrong? What if Mr. Shaw isn't right? Who carries that risk? Is it the consent holder or is it the airport? Well, the answer is it's the airport. Because if there is a bird hazard problem, if there is an aviation accident, the consequences of that get visited upon the airport under its Part 139 certification. The Civil Aviation Authority does not regulate landfills. It can only regulate the airport. And it does that by exerting controls on its operations. And that is a direct link back to the regional policy statement framework, where constraints on the operation of infrastructure of national significance are to be avoided. Now, if they are avoided, that's great. The airport doesn't have a problem. but it simply does not have confidence that security about that can be achieved through consent conditions. So, coming to the oral evidence of Mr. Shaw, if everything he says comes to pass, we don't have a problem. But he was clear that his opinion as to risk relied upon perfect performance of the conditions by the staff on the site. Dial has no confidence that that will be achieved. And the reason for that is not only because of the difficulty and complexity of counting birds and controlling them all day, every day, but because it sets up staff on site to operate within a conflict situation. And that conflict is, on the one hand, the landfill operating efficiently and cost effectively, which is of course what the contracted operator will want. And on the other hand, recording the presence of birds that could threaten that very operation. Put yourself in the position of a landfill worker having to decide whether to risk shutting down that operation by counting birds or not. That's a horrible position to put staff in. And Dial does not have confidence that over the 40-year term of these consents, that will not result in a problem on that site that Dial will not know about until it's too late. It seems to me, from listening to Mr. Shaw's evidence, that his assessment is that the primary risk of bird hazard to the airport is not Smooth Hill, but the closure of Green Island. And what he seems to be saying to me, this is how I understood it, was that if this consent is granted, the Dunedin City Council will behave responsibly in reducing bird numbers at Green Island before it closes. But if this consent is not granted, then it won't. That, to me, is a threat. And it is a completely irresponsible position for a local authority to take. If the local authority has, through its operation at Green Island, created a hazard to aviation through enabling thousands of birds to settle there, then Dunedin Airport would expect a responsible local authority to deal with that problem, whether the Smooth Hill consent is granted or not, rather than it being presented to you as some form of risk offset to trade off Green Island for Smooth Hill. My submission is that you should not be influenced by such a threat. If the Dunedin City Council was serious about how it should deal with Green Island, then it should have applied for the Green Island consents to extend their life as part of the package of the consents that you are now dealing with, so that management of the Green Island site was directly within your jurisdiction. They did not do that. So although I have no doubt that Mr. Shaw was sincere in his understanding about a commitment to manage birds at Green Island to reduce the hazard, the likelihood of blackback gulls relocating to Smooth Hill, the fact is that you are left without the regulatory tools to ensure that happens. You don't have the Green Island consents in front of you to require management of birds on that site as part of the decommissioning of that site. And if you accept that that's a scope problem for you, then the offsetting of risk that Mr. Shaw relies upon falls away, because you can't ensure that it is delivered. And so that really explains the difference in the evidence between Mr. Dale and Mr. Bonis. Mr. Dale was quite clear that he accepted Mr. Shaw's evidence that there will be no increase in bird hazard, and therefore the avoidance policies in the RPS are satisfied. And that's fine, we understand the basis for that analysis. But Mr. Bonis is not convinced that there is no residual risk, and for that reason he comes to a different view. So that seems to be the stark choice that you need to make. Are you satisfied that there's no residual risk? Are you satisfied that you can be sure that the conditions will deliver no additional aviation risk? If you're satisfied about that, then Mr. Dale's right. But if you're not, my submission, Mr. Bonis's evidence ought to be preferred. I want to make a brief submission to you about reverse sensitivity and policy 4.3.5 in the partially operative RPS. Before we broke this morning, there was an exchange, I think, between you, Mr. Chairman, and Mr. Dale about whether an effect arising from aviation hazard was a direct effect or a reverse sensitivity one. My submission to you, there are both kinds of effects at play here. An aviation incident, impact between bird and aircraft, is a direct effect, but it's not an effect on dial. It's an effect on whoever's in that aircraft or whoever owns that aircraft. The effect on dial is the constraint on its operations that might arise from that risk. And the constraint on operations arises from regulatory decisions taken by the Civil Aviation Authority. So, although in the traditional sense the landfill isn't sensitive to the airport, nevertheless, from the airport's point of view, what is at stake here is constraints on its operation arising from the presence of the landfill. And so in that sense, interposing the Civil Aviation Authority as Dial's regulator between Smooth Hill and Dial creates the reversed sensitivity effect. So it's not like the Christchurch airport situation some years ago, where the establishment of houses around the airport, people started complaining about being kept awake at night by jets. That's the classic reverse sensitivity scenario. That's not quite what we're dealing with. But nevertheless, what we're dealing with is a regulator that could be motivated to constrain the airport arising from the presence of the landfill. And so it is a reverse sensitivity effect from the airport's point of view, because the effect is not direct. The direct adverse effect on the environment is an aircraft hitting a bird It's not Dial's aircraft. It's not Dial in the aircraft. So what the policy 4.3.5 is designed to do is manage effects on the airport as a national infrastructure item. So it's the constraints on the operation of the infrastructure that the policy is directed to addressing. So my submission, the reverse sensitivity limb of that policy is engaged, and it's engaged because of the CAA's regulatory function, which can only serve to constrain Dial in the event of unacceptable aviation hazard. Now, what I want to do now is to take you to Mr. Dale's conditions. And I want to start on page 13 of the condition set. At the foot of page 13 you will find condition 43, which is the condition that manages highly odorous wastes. Now, Dial's position is that none of the waste types in that list are appropriate at this site because of the proximity of the airport. They are all waste types that have to be separately identified and trucked, and so Dial can see no practical reason why the truck just can't keep going south. It doesn't have to come to Smooth Hill. This is not material that's inextricably mixed with other material that has to come to Smooth Hill. It is simply a commercial decision about where it goes. So that's why Dial's eyebrows are raised about Mr. Henderson talking about the business case. Why does this stuff have to come to Smooth Hill? What is it about the business case which says it has to come there and nowhere else? The answer can only be commercial, as Mr. Keogh's evidence explained. Winton's already receiving this stuff all of the time. Now, the second aspect is condition 43E. Now, there are tracked changes in 43E. Highly odorous wastes must be covered as soon as practicable and in any event not later than 1 hour has been crossed out and 30 minutes has been replaced following placement. Now, I don't know why. I haven't found why 1 hour has been crossed out and 30 minutes has been replaced, but the point I wish to identify for you is that Mr. Shaw's evidence was that that material would be covered immediately. That is not what the condition says. Mr. Shaw's evidence was clear that birds must be given no opportunities to feed. For a seagull, half an hour is plenty of time to have a feed. So the condition doesn't do what the expert said it must. Now, I want to mention condition 82. And I want to explain to you where that came from and why it's there. Because it was developed between the Dial team and the DCC team in the weeks leading up to hearing, as an attempt to find a way, if consent was to be granted, how might Dial actually be involved in its management? So that's what this is for. So we don't raise a jurisdictional objection to the mention of Dunedin International Airport Limited as a member of that group, because if you grant consent, Dunedin Airport wants to be on that group. And the reason why the group has 3 members, the airport operator, you'll remember Sandy Graham telling you that they're going to contract someone to run this thing, so that's the airport operator, the City Council itself, and Dunedin International Airport. There's a reason why we came up with those 3. And that is because the Dunedin City Council has a foot in both camps, if you like. It is a half owner of the airport, and it is also the contracting party to the operator. What we envisaged is that there would inevitably be a tension between what the operator wanted to spend and what the airport wanted the operator to spend. And so by having those 3 on the group, with the airport, with the City Council effectively sitting in the middle as referee, we felt that there will be a sufficient balance of interests to make that group work. So that's how that came about. And the idea behind the group is that it would have the authority to require the consent holder to escalate responses to bird hazard, whether or not the thresholds in condition 80 had been met. Now, Commissioners, I note, particularly Mr Chairman, your comment about whether it's the regional council that has that power or not. Respectfully, Dunedin Airport doesn't have confidence that the regional council as regulator can be, this is not a will thing, it's a capacity thing, can be as responsive as the airport needs it to be to respond to escalating bird problems. So that's why condition 80 has got reporting requirements to Dunedin Airport. So Dunedin Airport should know in a timely way if birds have turned up. And Dunedin Airport can then call a meeting of the operational group and lobby that group to require the consent holder to escalate management responses if it hasn't done so already. And I again appreciate your comment, Mr Chairman, that Mr Shaw's evidence seemed to suggest that responses would be instant anyway. But what Dunedin Airport is trying to do is to reserve to itself some influence over getting stuff done. So that's why those conditions are structured in that way. I hope that's some helpful insight as to how we got there. We're not saying that these conditions are a complete answer. Dunedin Airport's concerns remain. We still say this is fundamentally the wrong place. But if you accept that there will be no increase in risk, then these conditions are designed to give the airport some comfort and some influence over how operation takes place. Now, the last aspect of the conditions that I want to discuss is attachment 3, which is the residual putrescible waste separation methodology. Now, including this methodology was a compromise that we came to, we being the Dial team and the DCC team, as a consequence of not being able to find a way to draft an enforceable condition which said you can only have X percentage of putrescible waste. Because we don't know, we being Dial, don't know how that percentage would be derived. Is it by weight or is it by volume, degree of contamination? And how is that counted? Is there some kind of scanning process at the transfer centre which will identify putrescible and non-putrescible? We just don't know. So operationally, it felt like we were setting the consent holder up to fail by saying, look, you can have 5% putrescible waste but no more, because we would never know whether it was 5% or 3% or 10% or some other number. We just don't know. So rather than settle on a number, where we decided to go is, look, if your methodology is sufficiently robust and enforceable, and you are following it, and we know that you are following it, then maybe that's the alternative way around this. And so Mr. Henderson put his thinking cap on, and this is what we've got. And frankly, it's from Dial's point of view, it goes a long way to give us some comfort that what the city said they're going to do is what they'll do. The problem comes, from Dial's point of view, when we deal with the special disposal procedure for contaminated wastes under clause 3. Because what we understand will happen is that all municipal waste will come to the bulk waste transfer centre. I'll just pause there for a moment. There's some doubt about that because we're not sure whether only Dunedin City's municipal waste is going to go there or whether all sources of municipal waste will go there. For example, is it going to take waste from Clutha or Waitaki or Central Otago District? And if it does that have to go through the bulk waste transfer centre too, or will it come already sorted? We don't know. But assuming for the moment that everything does go through the bulk waste transfer centre, it is then split and sorted, as the methodology explains, and the contaminated material is handled as a contaminated waste under the special disposal procedure. Well, we're okay with it until that point. The problem is, having identified it, sorted it, containerised it and trucked it, it's still coming to Smooth Hill anyway. Why? Having separately identified it and sorted it and put it in a truck, and knowing that it is a contaminated putrescible waste, why does it have to come to Smooth Hill? Dunedin Airport just does not understand that. Why not take it to Winton or any other Class 1 landfill that is certified for taking this type of material that is not 4 kilometres from an international airport? Again, the only explanation for why is that, well, the business case says no. So there's something going on here that Dunedin Airport doesn't understand. And the conditions and the evidence don't explain about why this stuff has to come to Smooth Hill. So what do we say should have happened? Well, my submission, in order to comply with the Act's requirements in the RPS, there had to be an alternatives analysis that started from first principles, that took into account the relative aviation hazard of competing site options, and dealt with the closure of Green Island as part of the same package. But they didn't do that. They treated the site as a given because it was designated in 1995 without talking to the airport. And they've never fundamentally gone back to ground zero and said, was that a good idea? It's been mitigation, mitigation, mitigation all the way. The opportunity for avoidance seems to have passed us in 1992. And that's why we say you shouldn't grant consent. Those are my submissions.
Thank you, Mr. Page. I'll see if we have questions arising from the pre-circulated legal submissions and your verbal presentation this afternoon. Are there any questions from Mr. Page?
Good afternoon, Mr. Page. I've got a couple of questions for you. One may be more appropriate for Mr. Richards, but I'll mention it anyhow. So the first one is, I guess in terms of, I'm intrigued by the history of the process that you've described in that dial suggests that it hasn't been consulted at any point in terms of the earlier designation. Mm-hmm. And I think from memory also the 2GP. And I'm curious to see how that might happen given the responsibilities of the airport and the sensitivities of its operations. My experience is that most infrastructural agencies have resource management consultants overseeing plan changes in the area to alert the organisations or the board of directors or what have you. So I guess I'm curious as to how that's played out.
Well, I'm not suggesting that the rollover of the designation from the operative plan to the 2GP wasn't publicly notified to include the designation which is in the 2GP. That clearly happened, but Dial did not become aware of the significance of that Smooth Hill rollover as part of that process. It simply missed it. Why? I don't know. What Dial's position is that there should have been more than that. When you are designating or renewing a designation within an existing designated area, there was a positive obligation on the Dunedin City Council to actually say to Dunedin Airport, this is what we're doing, can we have your feedback? That's the part that we're missing.
Yeah. Okay, thank you. And my second question relates to the reverse sensitivity matter, and appreciate that you've set out that that in your opinion it's not necessarily the conventional application of reverse sensitivity in this case, but is there any case law that would support that assertion in the sense that given it's not a typical application of reverse sensitivity in a planning context, have you got some examples for us where you can point to that being applied in the way you've suggested?
No, I haven't, and the reason for it is that we've got an unusual situation where we've got a different regulator involved, because the constraint on the functioning of the infrastructure that the RPS refers to doesn't come from anything that the ORC does. It comes from the statutory powers exercised by the Civil Aviation Authority, and so that is an unusual set of circumstances in a planning context. So can I point to other airport cases where it's described as reverse sensitivity? No, I can't.
Sure. I appreciate that there might not be an exact replication of the context that we have in front of us, but assuming there might be other cases where there are specific circumstances where reverse sensitivity may be applied in the way that you've suggested.
No, I can't point you to any.
Okay, thank you. Move on.
I've just got a few points to pick up with you, some of them legal, some of them just responding to your oral submissions. So I'll just start with the points you've just been making, and then I'll go back to your written submissions. The first one relates to you talking about the city apparently not being happy to truck their waste or their special waste further south to Winton, or take in waste from other places and deal with it in different ways. The understanding I got from reading the evidence, and I'm not talking so much about the business case, but the council's evidence seemed to be that their Waste Futures program wasn't just talking about waste, it was also talking about reducing emissions and that sort of thing. So they didn't want to be having trucks racing out of the district necessarily. That was one of their reasons, and the other one seemed to relate to wanting to keep control of the city's waste and the operation of the landfill. I appreciate that point and why you're concerned about that, because lots of councils throughout the country take their waste to a large regional facility, which means they don't have to have one. Completely get that, but this council seems to have those two reasons as part of its reasoning. Reasons as part of its reasoning, rationale for what it's doing. So do you accept those 2 points? Because they are in the evidence. I think Mr. Henderson talked about that.
Well, if it was a carbon reason, then we would have expected to see an analysis of the carbon consequences of trucking elsewhere. And what we know about AB Lime's operation is that it uses its lime truck fleet to backload to Winton. It's trucks that are already on the road.
Right.
And that's what's happening now. Waste Management from Dunedin takes all its material to Winton, backloaded in lime trucks. So is there analysis which sits behind a carbon reason for not trucking out of the city? No, we haven't seen any analysis of that.
No. Well, you might recall yesterday I asked the Economist whether he'd been asked to look at, I think the way I put it was, the reduced size of the footprint and an economic analysis of the mitigation that's now being proposed.
Yep.
And the reason I was asking that was because it did relate to trucks, but it also relates to a fairly small scale landfill at 18.5 hectares is pretty tiny.
Yes.
Probably doesn't seem like that to the submitters, but to, you know, in relation to Cape Valley or Hampton Downs, I mean, Hampton Downs is about 87 hectares, I think. There's an awful lot of conditions to deal with 18 hectares, so I was concerned about the balance that was going on economically for that, in terms of what was being put on the table, as you say, mitigation on mitigation, versus what might be coming through the gate. And so there isn't, I mean, the Economist confirmed he hadn't been asked to look at that. So
Yes.
I'm just making that point.
Yeah, and I couldn't help but be struck this morning by the irony of the engineering witness who was talking about bringing lime to site to stabilise the lures. That's interesting. I wonder where that's coming from.
So just turning to your written submissions, because I've got a few points here that you've raised that are legal ones,
Yes.
and as the lawyer on the panel, I should probably ask you about them. The first one is paragraph 6. And this is where you were talking about, and so who talked about this yesterday?
Mr. Garbutt did.
Mr. Garbutt did. I thought that the submissions that he was making had some merit, because the way that I read that wording suggested to me that the obstacle would refer to something like a crane or a structure, maybe a drone, but that was pushing it, but I was thinking more of a crane.
Yes.
Where that would be. So do you want to revisit what you've submitted there, or are you going to stick with the same point?
The trouble is that there is a subtle difference between the wording of the advisory circular and the wording of the designation. Because the advisory circular that I've referred to in my submissions is very clear that it applies also to temporary mobile obstacles. Whereas the drafting of condition 11 of the designation doesn't pick up that language in quite the same way.
Right.
Because there is, where it's condition 11 says constructing any structure which includes any building, aerial, comma, antennae or other object. For the drafting of condition 11 to be consistent with the advisory circular, we would need to put a comma between antennae or other object.
Right.
Because the advisory circular doesn't link the notion of an object to a structure, whereas the drafting of condition 11 does. So the regulatory regime under which the airport is subject to has a subtle difference in language to designation 11. Sorry, condition 11 of the designation. But I guess, and I said in my submissions, Dial's position doesn't really hang on this.
No.
What I was trying to draw your attention to is the conical surface, and the dimensions of the conical surface are defined in condition 6. Do you have designation D274 that Mr. Garber handed up yesterday?
I mean, you don't need to go
Yeah.
down this
All
road
right.
if it's not your main point. I just wanted to
No.
give you the opportunity to revisit that submission,
Yes.
given what he had said. So,
Yeah, well, it's something that you don't need to decide whether granting consent to a regional plan consent is going to put Dunedin City in breach of Dial's designation, because that's an enforcement matter for another jurisdiction. So you simply don't need to decide it. What Dial says is that the surface of the ground is roughly at the same elevation of the conical surface in the plan, so it is vitally interested in anything that happens from an aviation safety point of view.
okay. Turning right over now to page 10 and paragraph 35. And paragraph 36 it is, and really what's following down from there. You would have picked up yesterday, had obviously read all of the Wasteman's documents, because I took Mr. Coombs through some of that. So I understand the point that you're making in here, but when I read on a little bit further from where you're referring to in these paragraphs, it does mention the no closer than 13 kilometres, as you say, but then it does go on later to say, to not say, I should say. It's a sort of the words are not as prescriptive as I think you were suggesting. So it was basically, there's nothing to say do not locate near airports. But it talks about minimising birds at sight, not avoiding birds at sight. So they're just being a lawyer here, but it was clearly not envisaging that there would never be a landfill near some sort of airport. I mean, there aren't very many that I can think of at all near airports, but I'm just saying the Wasteman's guidelines don't actually prescribe that or say in any way don't go there. So I was looking for something, given what you were referring to, that might be a bit more in the avoid kind of category, but actually it was more about minimisation.
I can't disagree with you about that, but the part of the Wasteman's guidelines that I've referred to there is the part that deals with the process for site selection, rather than how you manage the site.
Yeah.
And so the point of tracing through that is to say that the site selection was made without the benefit of following the process in the Wasteman's guideline.
Right.
We can't know if the Wasteman's guidelines were applied to the various alternative sites that were available in the 1990s, what decision the city would have made.
Right, okay, that's fine. Yes, well, when you get to the later bit that I'm talking about, that really is not about site selection, it's about practice.
Yes.
Yeah.
Yeah,
So a lot of the things that it says about practice are in fact being promoted now through the drafted conditions and red lines, and no doubt the next version to come. So I'm just thinking of
Yeah, I accept that.
Yeah.
But the problem that we're trying to advance is that we shouldn't be here, because if what we know now about how you select landfill sites was applied at the time, we wouldn't be talking about Smooth Hill. That's another
Understand.
these Dial's position.
Okay, that was all I had for you. Thank you.
Thank you.
Mr. Page, there's just 5 matters I want to ask you about. The first is, and they're all in response to the verbal presentation that you've given us this afternoon. I was interested to hear you say that in your view, the City Council won't control birds at Green Island if Smooth Hill is declined. What's the evidential basis for that statement?
Well, I took from Mr. Shaw's saying that the closure of Green Hill is going to be, so Green Island is going to be a problem, because they're going to go somewhere, is saying there isn't an intention to manage that problem other than through these conditions.
Yeah, that doesn't quite answer my question. Can you point me to any evidence where the City Council has said they won't control birds at Green Island if Smooth Hill is declined?
No, they have not said that. But neither have they said we will control birds at Green Island whether or not you grant consent.
Yeah. And look, I just don't want you to think my questions mean that I don't understand the significance of this issue and the fact that this is one of those adverse effects that has a low risk of occurring but potentially catastrophic implications. I'm well aware of that, but there are a number of things I just want to ask you about. You mentioned Te Runanga's opposition to the alternatives that Mr. Keogh is going to talk to us about shortly, and particularly the evidence of Edward Allison, who I'm sure you're very familiar with, and his status is beyond question. Explained why Te Runanga oppose trucking waste out of the district and why they oppose incineration. It's pretty well established, isn't it, that it's appropriate for iwi to enunciate their interest and values, and only they can do that, and it's not the place of some other party to assume they can do a better job of that. And I think there's even been some quite recent High Court case law that says the evidence of iwi and kaumātua in that regard doesn't even have to be of a probative nature anymore. It's just to be taken on face value. Is that correct?
That is correct. The question is what weight you give it. That's for you.
Yeah, okay. The issue of the City Council undertaking bird or southern blackback gull control measures at Green Island is of interest to me, because that formed quite an important limb of Mr. Shaw's evidence to us. And I think I might have even said to him that, I wasn't confident that we could actually impose conditions on the applicant that would require them to do things at Green Island. But if the applicant was to offer on an OGIA basis comprehensive conditions mandating the control of those seagulls at Green Island, regardless of the outcome of this process, even OGIA conditions are binding and enforceable, aren't they?
Yes, they are.
Yeah.
The difficulty I have is that I'm not at all sure that the evidence is clear about where the nesting sites of these blackback gulls are, and nor are we clear about the tipping point for the offset. How many blackback gulls do we have to kill in order to achieve a zero increase? I don't think you have that evidence.
Yeah, and I was only in my question to you then referring to Green Island. You may recall that I posed the question to Mr. Shaw about the breeding colonies, and he corrected me. I'd got the map here attached incorrect. That was only where they seem to hang out. It's not where they breed. And so my question was only about Green Island, not going to the breeding colonies. I agree that's a more complicated matter. Just coming now, two more questions. The proposed regional policy statement 4.3.5 and this issue of reverse sensitivity. Not sure I'm persuaded by your submissions on that. I will give that some more thought though. But I would appreciate hearing on that matter from Ms. Mel Hoft in reply, not in reply, when we hear from the 42A officers and then also applicant in reply, if there's anything you want to add to that from a legal perspective. But I just wonder if we need to go down that rabbit hole. If we were to decide that bird strike has obviously a potentially significant adverse effect on the operations of the airport, and Mr. Shaw's evidence, who speaks or gave evidence on behalf of the applicant, is that there should be an avoidance of any exacerbation of the existing risk. I mean, that's a sufficient threshold for us to have in mind, isn't it? We don't need to go down the reverse sensitivity rabbit hole, do we?
No, probably not. I'm just mindful of a submission that could be made that just because an aircraft gets taken out of the sky, that's not an effect on Dial. Dial's position is that it is, because it will result in regulatory constraint.
Yeah. Well, I can't speak for the panel, but certainly on the evidence I've heard, if there was to be an adverse impact on an airplane as a result of bird strike that's attributable to Smooth Hill, I would have no problem considering that to be an adverse effect on the airport.
I'm happy about that.
If that gives you some comfort.
It does.
Excellent. Now, I just want to lastly look at this issue of alternatives, which has been the focus of the airport's case, and also a number of other submitters are probably going to speak to us about that. But the fact of the matter is that Smooth Hill is a designated site. The process for rolling over that designation has been and gone. The decision of the regulatory authority, the District Council in that regard, is beyond challenge. I don't even know if you could take a judicial review at this stage. Is it past the limitation date for doing that kind of thing? I don't know. So I just kind of question the merits of going down that path. And in terms of sort of arguments, what should have happened, well, what happened did happen, and what should have happened could include the issue that my colleague raised. An equally valid argument is that the airport should have submitted an opposition to the designation, the rollover, and it should have appealed that decision if it was unhappy with it. That didn't happen either. So but in terms of alternatives, we are legally obliged to look at alternatives in two manners, two areas, aren't we? Section 105, where there's a discharge, we have to consider alternative receiving environments, and that's pretty routine, and we do that all the time. And then Schedule 4, Clause 6A, if we think there's a potentially significant adverse effect, we need to think about alternatives. Yes. So I'm going to get to my question in a minute, so bear with me. So my question is, in terms of Schedule 4, Clause 6A, and the issue of significant adverse effects, in considering that, do we take into account consent conditions in terms of how they might mitigate that effect? And that's sort of like a legal question I'm interested in the answer to from you, and also from Ms. Melhoff and from the applicant in reply. I think I know the answer to it, but obviously I'm not a lawyer, so do you have a view on that?
Well, I think the answer is that yes, you would take into account conditions.
Yeah.
Because that sets the scope of the inquiry about what is the adverse effect.
Yeah.
The trouble is, when you're drafting an assessment of effects on the environment, you don't know what the conditions are going to be. You might promote some, and those might be taken into account as defining the scope of the proposal.
Yeah, well, we could just impose them. That's our job, isn't it?
Yeah.
Our job's to make decisions.
It is.
Yeah. All right.
But,
No, that's helpful.
well, can I come back, because I think Mr. Garbutt and I are agreed on something.
Oh yeah, that'll be good. Good one. Tell us about that. That'll be interesting.
And I took it from an exchange between you and him when Mr. Garbutt opened, an acceptance that the application for the regional council consent under the waste plan triggered the obligation to consider alternatives. And so the fact that the site had been designated did not avoid the obligation under the regional consents to consider alternatives in that context. And that's Dial's position too. Absent discharging waste into the ground, there is no effect that Dial is worried about. So it's not the land use that bothers Dial, it's putting waste in the ground. And that's a regional matter and always has been.
You can't recall the section of the regional plan waste, can you? You don't need to, if you could come back to us on that.
It'll take me about 30 seconds if you want me to.
Yeah, well, we've got 30 seconds to spare, so go ahead.
I think it's Rule 761. New landfills are a discretionary activity. The discharge of any contaminants into onto land, discharge of any contaminant into water, and discharge of contaminants to air. So the consent under the rules of the waste plan are always, because they are discharge consents in terms of the structure of the RMA, the Section 15 consents, they trigger the obligation to consider alternatives.
Oh yeah, by way of Section 105.
Yeah.
Yeah, that's what I said before. Yeah, totally alive to that. Yeah, That's good.
So I don't think there's any dispute between the parties about is there an obligation. We're only at odds about whether they've satisfied it.
Yep. All right, thank you. I don't think we have any further questions for you, so we can hear from your witnesses.
Lovely.
Now.
So first up is Mr. Roberts, who hopefully has been watching and listening to all of that.
Yep, thanks Phil. I have been watching and listening.
Excellent. Good afternoon, Richard. I'm sorry you can't join us this afternoon. Now, Commissioners, you don't want me to get him to confirm his evidence, I understand.
No, that's all good. Yep.
So Richard has explained to me that unless something has happened during the course of my presentation, there's nothing particularly that he wishes to add to his evidence, and so he's there to assist you and answer questions that you might have.
Excellent. Thank you, Mr. Roberts. I hope you're not feeling too crook, but thank you for making the effort to come over Zoom.
Yeah, I'm not crook, it's my wife who tested positive this morning, so I'm just waiting for the positive result.
It's a bit strange how it's called a positive result, isn't it? We'll just see if we have questions for you. Jan, any questions for Mr. Roberts?
I've just got a couple of quick questions, Mr. Roberts. First of all, there's been a bit of evidence come in from the airport on the flight paths as they now appear to be coming into the airport. And I just wondered whether those flight paths have been consistent over the last, say, 30 years or so, or whether they've changed as a result of technology and so on.
I couldn't answer that question for you. I would defer to Daniel, GM Infrastructure, who may or may not be able to answer that question, but would be better qualified to than I am.
Okay.
But equally, we could seek that information as well.
Oh no, I just wanted to know if you knew. That was all. Somebody else here may be able to say something about that. In your evidence, and Mr. Page has confirmed this in his submissions today, there's been a suggestion that of a lack of confidence of the airport in the operations that might go on site, and whether some of the bird control methodology might be achieved. I was just going to ask you, because there has been a talk of the DCC owning the site and remaining as the consent holder, but bringing in an operator, which is what it does at Green Island. Would your level of confidence change at all if the council owned and operated the whole thing, or does that not make any difference to you at all?
No, personally, I don't think it does, because I still see the conflict that Mr. Page raised, in that there is a conflict between you've got the duty to control, but the consequences of lack of control, or lack of performance, are that there could be significant consequences on your operation. So that wouldn't.
Okay, that's fine. That's all my questions for you. Thank you very much.
Thank you.
Any questions? No? Mr. Roberts, no questions from me either, but thank you very much for your evidence. We appreciate it.
Thank you.
Good
Thank you,
luck.
Richard. Now I'd like to introduce Mr. De Bono, who Mr. Roberts was just referring to a moment ago. So he's able to, I don't know if he can answer the question, but at least be able to address it.
Good afternoon.
Good afternoon.
Now what I propose to do with Mr. De Bono is ask him a series of 4 questions that have arisen out of the evidence yesterday, and invite him to comment on that. But before I do that, I will ask him to turn his mind to the question that Commissioner Cornton just asked of Mr. Roberts, which is whether flight paths are likely to have changed over the last 30 years.
The best way to answer that question is most likely I would need to confirm that by going through historic records of departure paths from Dunedin Airport, but technology has changed in the last 25 to 30 years, so it is probable that flight paths have also shifted. It's certainly within the realm of flight path optimisation and procedures, as we call it. There's a view to reducing track miles in the interests of reduced fuel burn, reduced flight time, as we move towards more sustainable aviation. So does that answer your question?
Yeah, well, it sort of seems to have been a pattern throughout the country from what I can see when
Yes.
I'm flying, but it's also just the turns in a way seem to be quite a lot sharper.
Yes.
Would that be right? Yeah. Okay.
Mr. De Bono, is the departure path for aircraft heading to Australia a relevant factor in flight paths over Smooth Hill?
Yes. Yep. Again, contingent on many conditions, that being the direction of the wind, airspace configuration at the time, other traffic, and of course flight crew's desire based on other aspects of that aircraft configuration.
And in the 1990s, were there international direct flights to Australia from Dunedin?
I believe so.
Now, the next question I have for Mr. De Bono arises from Mr. Shaw's description of the ICAO guidance in relation to landfill location. And he described it, if I understood him correctly, is that it didn't require avoidance but management of risk. Is that your understanding, Mr. De Bono?
No, I mean, I would suggest that the international guidance is geared more towards changes to land use in proximity to aerodromes, not the management of existing. And when I say that, I talk about the principles that exist within safety management, being the hierarchy of control when we deal with a hazard. And predominantly, you should start at the position of eliminating the hazard. Only if it's impracticable do we go down the road of looking to minimise the potential adverse outcomes of that hazard, if that makes sense.
In relation to Dunedin International Airport Limited's own safety management system, does it deploy the same hierarchy of control?
Absolutely, and that's something we're compelled to do as part of our safety management system as regulated by the Civil Aviation Authority. The elimination of the hazard is the first step in that hierarchy of control. And that is also consistent with obligations under the Health and Safety at Work Act as well, when we come down to workplace safety and hazard management generally.
One example of a hazardous practice that concerned Mr. Shaw at Dunedin Airport was what he described as grass harvesting. Is Dunedin Airport required to mow its grass?
Yes. If we weren't harvesting the grass for the purposes of supporting our neighbouring dairy farms, we would still need to cut it, to put it bluntly. We can't let the grass get out of control, and from a wildlife hazard management standpoint, if we weren't harvesting it for the purposes of supplementary feed on the farms, we would have a mowing regime in place to ensure that grass was at an optimal height to best mitigate wildlife hazard.
Mr. De Bono, the preliminary wildlife hazard assessment conducted by Amy Shaw and Botham Miskell, is that an equivalent exercise to an aeronautical study that would be required of Dial in this situation?
I would argue not. I think the preliminary wildlife assessment in itself is preliminary, and it doesn't consider the wider impact on Dunedin Airport's operations on risk in totality. And even to get down to some of the detail, there's no reference or consolidation of some of the evidence I have submitted on flight paths. It is stated in that evidence that there is minimal or reduced low numbers of aircraft traffic over the Smooth Hill site. Now, the evidence I have presented would suggest something quite different to that. The large number of red lines, which are aircraft below 5,000 feet, that cross over the Smooth Hill site on a departure with a reasonably high power setting, and those are aircraft ranging from A320s down to ATRs and everything else in between.
Thank you. I've got no additional questions for Mr. De Bono.
Thank you, Mr. Page. See if we have questions for Mr. De Bono. Jan, any questions?
Yes, I have got a couple. I'll just turn to that last point you were just making because I've actually got a question around that, and it's in your paragraphs 21 to 23 of your evidence. So you've got your figure 1 showing flight paths, and then in paragraph 21 you talk about an aircraft flying at an altitude of 2,000 feet as it crosses the site, but us to be aware that that's only 1,640 feet because of the ground level and so on. So what I'm trying to get clear in my head is, is there reliable evidence that these gulls are flying at that height?
Based on the evidence in the preliminary wildlife assessment, I would say no. However, as I understand it, these birds could be up to heights of 5,000 feet above the ground.
Seems quite high, but...
It does.
Yeah. So just talk around that in terms of what you know about it.
Essentially what I've said, so in the absence of more information and longitudinal studies on the behaviour of these birds in the surrounds of Dunedin, I don't think I can come to any conclusion of what altitudes the black-backed gulls could be soaring at above the site.
Right. Paragraph 11, so I'm just going to go backwards in your evidence. My point to you here is just for me to clarify where I think you and Mr. Shaw seem to have got to. You don't seem to be disagreeing that there is already quite a significant bird strike risk at the airport. Is that
Correct.
right? You agree with that?
Correct.
And his evidence is that the landfill won't increase that risk, and you say that it will.
Correct.
Yep. Okay, good. Is it your approach then that you do not want to see any birds at the site, because this seems to relate to the acceptance of waste and putrescible waste and special waste and so on? That's what I'm reading from the airport's evidence, but is that what you're actually really intending to say?
To some degree, yes. But I think as it's been covered in Mr. Shaw's evidence, the risk varies between species of bird. So this trigger of birds greater than 50 grams, I think, is quite key. in my answer.
Yeah.
That larger mass birds that have a higher propensity for soaring are of considerable concern to us, and unfortunately the black-backed gull fits the mould.
Yep, and they're quite big. Do you have any experience of this sort of approach at any other airport with the size of the gull and what's required to be done? Do you know of any other examples of that?
I was previously the manager of the Airfield and Airport Fire Service at Wellington Airport for some years, and in my time there I was responsible for the wildlife control program.
Right.
In Wellington, given its coastal location, that comprised of a fairly significant black-backed gull monitoring and control program in the surrounding coastline and islands around Wellington Airport. That involved active black-backed gull surveillance of nesting sites, breeding behaviour, and oiling of eggs and nest controls as part of an ongoing basis. And that came in this would be 6 or 7 years ago since my time there, but at a significant cost to the airport operator to maintain that program. And the black-backed gull at that airport is of concern.
Okay, but have there been any issues there that you're aware of that would help us in our assessment of risk here?
Other than the black-backed gull will feature reasonably highly in bird strikes at Wellington Airport.
Okay, and what was the magnitude of the effect of that?
It can range from aircraft delays due to serviceability requirements or aircraft needing to be serviced or checked. I do recall an incident in my time at Wellington Airport where a Air New Zealand aircraft ingested a black-backed gull on arrival into Wellington. It was inspected on the ground in Wellington by the engineers and cleared safe for flight.
Right.
Return flight to Auckland. Subsequently, on the approach into Auckland, that engine failed.
Okay. Is this when we get our famous announcements about your flight is delayed for engineering reasons or something?
Correct.
Such thing? Right, okay. I often wonder what that's about.
Yep.
How many engineering reasons there can be, but that might be one of them.
In this case, the black-backed gull went through the inner core of the engine.
Right, okay. Is there anything that you want to say in regard to the comments and discussions that have already gone on for the last day and a half about notification to the airport of the bird monitoring and the remedial action? I mean, this has been kind of tossed around a little bit already. Is there anything that you want to add to your evidence about that?
Not particularly, apart from my concern that escalation of measures and the requirement to be very responsive to the change in risk is something that concerns me. In the world of aviation that we operate in, we have to be agile and respond to hazards as they present themselves at the time, not days later, not hours later, but at the time. And in my view, that's critical to the safety of the travelling public and the protection of operations at Dunedin Airport.
Right. That was all I had. Thank you very much.
Commissioner, before I move on, there's a question that I should have asked Mr. De Bono. Mr. Shaw suggested that nobody at Dunedin Airport is responsible for wildlife management. Was that a correct thing to say?
No, not a correct assertion at all. We have a team of comprised of 16 to 18 airport firefighting personnel, and at any given time 5 of those staff are on duty providing the regulatory required firefighting cover. But in addition to that, they are airport operations officers, and one of their key responsibilities, and as they undertake that role, is wildlife control.
Right.
Sorry for the interruption.
That's right. Thank you. I'll just see if there's any other questions.
No further questions from us, Mr. De Bono. Thanks very much for your evidence.
Thank you.
Thank you, Dan. So now it's time to bring Mr. Sean Rogers on the screen. Good afternoon, Mr. Rogers. Can you hear me?
Tēnā koutou, yes, I can hear you.
Great, thank you. Mr. Rogers, were you online and listening to the evidence from Mr. Shaw yesterday afternoon?
Yes, I was.
One of the things that he discussed was his understanding of the ICAO guidance in relation to proximity to airports. Do you have any comment to make about that?
Yeah, I'd just like to clarify, if I can, some of the interpretation discussion around that aspect. So both the ICAO and the CAA guidance anticipates collaboration between councils or regional authorities and airports at the early stages of land use planning to establish bylaws that limit or restrict such land use activities in the interest of safety. For example, if you are allowing a type of land use within 13 kilometres, it must be done under certain conditions or meet certain criteria established through a comprehensive risk assessment. So it's a simplistic interpretation that this guidance is intended to allow any activity to occur within 13 kilometres, provided you collaborate with stakeholders. So I would have anticipated airport engagement well before the final consent phase of this project, with a view to establishing conditions on land use prior to specific applications being made. So without visibility of such discussions at the regional planning stages, looking at it through my aviation regulatory lens, I would reserve judgment on whether this proposal has met the intent of that ICAO or CAA guidance. I also wanted to just talk a little bit more on the risk considerations put forward by Mr. Shaw, if you're happy for me to continue.
Yes, please.
So firstly, when discussing the aviation safety events, he characterised the likelihood of event being extremely unlikely. And again, I think it's important to just clarify that that is a bird strike that results in a catastrophic event, loss of aircraft or life. This is an important distinction because from a data perspective, there have been 173 instances where a bird has struck an aircraft at Dunedin in the last 10 years, 6 of which have caused damage to the aircraft. That works out to be just over 1 bird strike per month. So in aviation terms, a bird strike is actually quite likely, though most of those strikes will have no significant consequence due to the size of the bird. So again, Mr. Shaw goes on to state in his professional opinion that there will be no change to bird strike risk. So in other words, no attributable change to the frequency of bird strikes or the size of the birds being struck, as either of these would indicate an increased likelihood of that catastrophic event. So I would again highlight that this judgment has been made on a preliminary hazard assessment with limitations, and in listening to the oral submission completed with less than ideal amounts of prior research in the form of longitudinal studies and such. So looping back to my original comment about the interpretation of the applicable CAA guidance, in my opinion, decisions on land use within 13 kilometres for whatever purpose should be made separately and have appropriate limitations and or acceptance criteria applied prior to any specific location approval. An example would be a consent would be granted upon completion of a full and comprehensive hazard analysis, including a longitudinal study. So this allows for a more informed decision making rather than that based on preliminary reporting or research. And again, that's speaking through my own decision making lens. So in an aviation context, the information provided in the wildlife management preliminary study does not provide adequate assurance that the risk to the safety of the travelling public has been mitigated as low as reasonably practicable. Should the proposed activity go ahead, then I can only place, or the CAA can only place limitations and conditions on the airport's aerodrome certificate. So this may include the immediate provision of a suitably scoped aeronautical study with a complete wildlife hazard assessment rather than a preliminary one. Moving forward, following the establishment of any approved landfill at Smooth Hill, any of the remaining regulatory controls the CAA can apply to Dunedin may be considered. So this may seem heavy-handed, and it is. It acknowledges that ICAO was established to standardise the global aviation in the interest of safety. This provides important context to the risk at Dunedin, given it's an international airport. For example, the likelihood and risk consequence considerations at Westport and Te Anau airports are different to those at an international airport. And in aviation regulatory terms, Dunedin's airport's operation is at the tip of the pyramid in terms of likelihood and consequence of its associated aviation risk. So one final point I wanted to make, listening to the description of the adaptive controls described by Mr. Shaw. This was described as a process by which event triggers are changed to the wildlife control measure. This is effectively a reactive mitigation strategy in which there is a likely lag between the action and the improvement outcome. So also assume the adaptive mitigation strategy would include triggers like a bird strike, for example. So again, to restate the obvious, we're not arguing the difference between 13 kilometres and 12.5 because the proposed site is more than half that recommended distance. So again, that from an aviation safety perspective changes the landscape quite significantly. So that's all of the comments I wanted to make, but I can answer some of the previous questions if you would allow me to.
So before I invite the commissioners to do that, Mr. Rogers, if I just understand you correctly, are you saying that if consent is granted, the Civil Aviation Authority is likely to require DIAL to prepare an aeronautical study?
Based on the preliminary wildlife management plan that I've seen, I would require a more fulsome safety study. So the answer in short is yes.
Thank you. Nothing further.
Thank you, Mr. Rogers. We'll see if we have any questions for you. Jan, any questions?
Just trying to get my head around all of those things. You've just said that was quite quick.
Apologise.
That's all right.
Would you like me to answer the procedure question?
Yes.
So in 2015, 2016, performance-based navigation procedures were implemented at Dunedin and various other parts of the South Island as part of our PBN project. So that is where you would have seen a fairly significant change to the procedure design and some of the routes and airspace design. And as an aside, we're about to implement an augmentation of the existing GPS signal, which will probably bring about another significant change to those, or to the available options for procedure design, which will, as you've observed, potentially result in tighter turning circles, etc.
And that applies no matter what the aircraft? I mean, these are all...
aircraft that are equipped for
right.
it. So you can take it as a given that it's all of the large aircraft.
Okay. Do you have anything that you can add to what Mr. De Bono was saying about the flight, where the birds might be sitting in terms of feet off the ground and that sort of thing? Have you got any knowledge of that?
Yeah, so I did make a note on that comment. So again, I'd go back to the origin of the 13-kilometre radius. So it talks about 95% of bird strikes happening at 13 kilometres, and that's attached to that 2,000-foot limit, because aircraft are at 13 kilometres when they are 2,000 feet on approach. So you can take it that above 2,000 feet, only 5% of bird strikes would occur. So in that particular example, they're talking about 1,600 feet AGL and 2,000 feet above sea level. So the likelihood is actually increased from the 13-kilometre risk.
Right, because they're...
But only marginally, I would say, yeah.
Okay. I just wondered if you had any comment to make about any other landfills you're aware of in New Zealand where bird strike is an issue?
That's a really long answered question. Wildlife is like weather. It's just something that you are constantly required to manage and mitigate. So to say that there were concerns at one airport over the other, they're always a concern. And part of our oversight function is to ensure that, again, particularly at the top of our pyramid in terms of aviation activity, that appropriate controls are put in place. And again, understanding my role is not to consent a landfill, but to ensure that it's been managed effectively.
So Mr De Bono talked about his experience at Wellington and having to control the gulls there. Auckland's obviously rather busy and rather large in terms of an airport size, and it's also on the coast. So do they have similar problems that are required to be addressed?
Yeah, so if you look at the 5 internationals, as you can imagine, they are quite tightly spaced together in terms of the reporting numbers. And I guess Dunedin sits a little bit higher in the ranking of reporting numbers than I would have liked for an international airport of its size compared to, say, Auckland, which does a fairly decent job at controlling its wildlife. Acknowledging that those 2 different locations have 2 bespoke environments and different characteristics that need to be managed in different ways.
So what do you think is pushing the Dunedin numbers up then?
If we go back over 10 years, there are trends up and down. It's a little bit challenging to make any definitive statements given the impact of COVID. So we saw a rise in bird strikes or in bird reports through COVID because the airports became quiet and birds became used to coming in and being undisturbed.
Right.
So it's a little bit difficult to pick out any long-term trends, but again, just going through this process itself highlighted some areas that could be looked at for improvement.
Okay. All right, that was all the questions I had. Thank you.
Tēnā koe, Mr. Rogers. I had a question around, you were listening yesterday to Mr. Shaw's evidence, is that correct?
Yes.
Yes, so if my memory serves me correctly, he was talking around some more recent survey work in terms of monitoring of the birds in and around the airport. And I wondered if you had a view on that and if that gave you any comfort or was sufficient in any sense to begin the process of getting some more longitudinal data. And you've just described the difficulties in capturing longer term trends, with COVID and what have you. So I was wondering if you could just talk me through your view on that, please.
So I haven't had any visibility of the work that's been done since the May 21 report that I was provided. But I did get a sense, or I didn't get a sense that from Mr. Shaw's oral evidence that the research was complete. So again, I'm not saying that this activity could or could not happen. I'm just saying there's not enough information for me to make a decision on whether it is being appropriately managed from an aviation safety perspective, acknowledging I don't have any decision-making role in that.
Sure.
So when I talked in my submission earlier about criteria, so I think that should be a minimum, a full and comprehensive longitudinal study, particularly when you're talking about not 12 kilometres from the airport, but 4.5 kilometres from the airport. That type of guidance should be the minimum standard. And again, listening to Mr. Shaw's evidence about mitigations like the net, I mean, in a HASWA context, we should be starting with the net already up and then working our way back and not the other way around. But again, that is what I would have expected, that type of discussion to be provided in a comprehensive study.
Okay, thank you. That's helpful.
Mr. Rogers, I just want to take you back to some of the verbal presentation and link it back to your written evidence. I'm looking at your paragraph 32. Do you have your evidence in front of you?
Just bear with me.
Yeah.
Yes, I do.
And so, just forgive me for forgetting some of the detail, but at your paragraph 32, you talk about the wildlife hazards assessment, which I think you referred to in your verbal presentation. So just remind me, so Mr. Shaw has previously worked for Dunedin Airport. So the wildlife hazards assessment you're referring to there, was that the one he's done for the airport, or was this the more recent one, or more recent work that he's done for the City Council?
This is the Smooth Hill Wildlife Management Plan dated May of 2021.
And you've talked about the absence of a longitudinal study. What exactly is that in your mind? What does a longitudinal study comprise?
A study over a significant period of, or a long enough period of time that is appropriate to make more informed conclusions or more decisive conclusions. So the report itself identifies 8 limitations, resulting in it being classified as a preliminary hazard assessment. So there's a good place to start about what I would like define as a full study.
You say study over a longer period of time, but I'm not getting a good understanding of what would be studied and over what period of time.
Yeah, well, I mean, a study would be of the potential impacts of the current and existing wildlife activity.
Okay.
So I could flip that question on its head and ask, and state that I would like a report that does not have that it's preliminary pending further study. I would like the further study to be completed.
Yeah.
And I'm not challenging, I'm not a wildlife expert myself.
Yeah, sure.
And I'm not challenging the conclusions specifically made, but the rationale by which they were made in.
So I think we understand, based on Mr. Shaw's evidence, that he's currently undertaking monthly bird study surveys, whatever, at Dunedin Airport or thereabouts, and you've got a couple of months to run, I think, from memory. So is that the kind of longitudinal study that you're referring to?
Yes, so that may or may not be reverse my sort of perspective.
Sure. And so once that data gathering process has completed, and let's say if at that stage Mr. Shaw updates his wildlife hazards assessment or his management plan that he's already produced to date, what would that non-preliminary document have to conclude to put your mind at ease?
If they can still stick to the statement that there is no change to the aviation or the bird strike risk. So that longitudinal study is focused on the wildlife activity. But again, drawing on some of the previous questions about the flight procedures, it needs to be included in what I would class as an overall aeronautical study and safety assessment. So what is the impact of potential changes to the bird flight paths on current and existing procedures, for example, and by procedures I mean instrument flight procedures that was questioned earlier on. So I haven't seen an exhaustive examination of that in the report either.
So sorry, I'm just trying to get my head around this. So the process might be that Mr. Shaw completes his bird survey data collection program. He updates the report he's already done for the City Council. It seems to have several different names. We'll put that to one side. So he updates that. That then quantifies whether or not the existing risk at the airport is exacerbated or not. Does that then feed into a further aeronautical study?
So maybe I'll explain it a different way. If Dunedin Airport were to provide me with the current preliminary report, that is my conclusion, that it's not, you're not managing that risk as well as reasonably practical.
Sure.
So, and I don't interact with the Mr. Shaw or the people that he's providing his report for. All I can do is ask Dunedin Airport for a suitably scoped aeronautical study that would include a longitudinal study on the bird behaviour and habits, current and what they may turn into, and in the context of all of the associated aviation safety risks, some of which have been highlighted by the panel.
Okay, just a couple more questions. I'm not sure if I quite caught one of the things you said towards the end of your presentation in response to Mr. Page's questions, but you said they could do more, I think you said. Is that so? You're saying that Dunedin Airport could do more to manage the current bird strike risk? You said Auckland does a really good job, and I think that was after you said that perhaps this airport could do more. Did I hear that correctly?
Yeah, so I guess listening to some of the submissions about some of the activities that have been that are already existing, maybe there are options to look at how we can change those to improve safety. So, for example, there's been a lot of discussion about the agricultural activities, so the grass harvesting. So there's a prime opportunity to look at, hey, how can we improve that?
Okay. Just one final question, and you may not wish to answer this, given that I'm not an aviation expert, I'm just a layperson in this regard, but you've told us the current bird strike incidents at Dunedin is 1 per month. What would,
if you take a historical average?
Yeah, sure. For you to consider imposing some of the measures that are at your paragraph 33, limiting aircraft movements, etc., what would that 1 per month have to increase to before draconian measures were imposed by CAA?
Yeah, so again, like that needs to be informed by a specifically scoped study. So it's not like a decision we would make overnight, because just one bird strike can bring down an aircraft. It's the level of comfort that we attain to be able to proceed based on that risk. And again, we're making a decision, or we're being required to make a decision based on a preliminary report. So again, that gives me a level of discomfort.
Yeah, all right. Again, this may be beyond your brief or your ability or willingness to do, but can you conceive of consent conditions that would require the City Council to undertake a process looking at the things you've talked to us about, the longitudinal study, no longer having a preliminary report, doing the things that you think need to be done to put your mind at ease? Could a condition be written to spell out what they would need to do to get you to a position of comfort?
That is a very sticky question. Because again, like I guess with the regulatory construct, what I would prefer is that the people that own the risk come up with the mitigation strategy, and in this case, I regulate it in the airport, they provide me with that strategy, and that's accepted.
Yeah.
So again, my legal, I'm pretty sure my legal counsel's watching this, but I would be uncomfortable articulating that directly to a decision-making process that I don't actually own.
Yeah, no, understood. But if say the Dunedin City as applicant is listening to this discussion and they're thinking, oh, here's something that we need to do some further work on, and if they were to put their mind to drafting a process type condition to address your concerns in terms of the studies and the things that need to be done, would you be able to assist them with that if they asked you?
Yeah, part of our regulatory function is obviously engaging with our participants. So, as I alluded to, based on the report that I've received, I would require some more work to be done, and we would engage in two-way communications to enable and facilitate that.
Great, okay. So what I've taken from that answer is that you would cooperate with Dunedin City if they asked you to help them look at conditions that might overcome your concerns.
Acknowledging that we also will be performing potentially a decision-making function in that.
No, totally understood. So, Scarlett, obviously that's something we'd be very interested in hearing some more. So sorry, Mr. Rogers, I'm just talking to the applicant now. So, yeah. So Scarlett, we'd be very interested in you putting some thought to that and coming up, see if you can come up with some kind of condition precedent which would say, for instance, before the commencement of deposition of waste at the landfill site or some other suitable words, that this process would need to occur and achieve a certain outcome to give CAA the comfort that they're looking for. I don't know if that's possible, but if you could give some thought to that, and Mr. Rogers said he'd be willing to help you with that if approached, that would be interesting for us to see, I think. Because obviously the view of the CEO is a pretty important factor in our decision-making process. All right.
And I only have some very blunt tools available to me.
Yeah, blunt, but, well, like anything that's blunt, they're reasonably powerful, so.
Yeah.
All right. No, thank you very much for your assistance, Mr. Rogers. We do appreciate it.
You're welcome.
Thank you, Mr. Rogers. You're free to stay or depart as you please.
Thanks, Phil.
Incidentally, the legal counsel that Mr. Rogers was referring to isn't me. CAA's lawyers are in the background watching this.
Right.
That's how I took it.
Okay, right. So next up, we move on from aviation matters to alternatives, and you have, I think, been delivered a copy of a summary statement that Mr. Keogh will introduce. Mr. Kieran Keogh, have you got that?
Yes.
You have. Yeah. Lovely. Well, Kieran, welcome, and feel free to read the summary statement. Hang on a minute. Before you do that, we need a microphone.
Thank you. Just to run through this summary of my evidence, I've been asked to advise if there are feasible alternatives to Smooth Hill for disposal of progressible wastes. My evidence identifies 4 viable options, and these being the Southland Regional Landfill at Browns near Winton, Mount Cooey and Balclutha, an alternative site, a possible alternative site in between Balclutha and Waihola, and extending the life of the Green Island landfill. But also in the background of this, in the medium term, there's the expectation that these wastes will be subject to government-initiated reduction programs or processing to render them inert. And I think we see the last couple of days the pronouncements from Wellington around the emission reduction program that there's going to be quite a focus on some of this. There are technologies available in New Zealand already that can actually process these wastes. It's a bit of an aside to that. But looking at the medium to longer term, I think that's quite an important option that needs to be thought of. Also, I'd like to clarify that while Dial is not a trade competitor with the proposed landfill, it could be reasonable to consider that Nash and Ross, with whom I'm associated as consultants, may be. I'm not presenting to this hearing on behalf of Nash and Ross, and also Nash and Ross's operation will not be disadvantaged by the establishment of a landfill at Smooth Hill. Smooth Hill will have a substantially higher operating cost than Nash and Ross's landfill and is likely to cause more waste to be diverted to the Nash and Ross landfill than is presently occurring. So it's advantageous rather than otherwise. This effect's already evident as wastes are presently being actively diverted from the Green Island landfill to Nash and Ross landfill to preserve the remaining capacity at Green Island landfill for domestic or council collected wastes by the manner in which DCC are charging for wastes. This is evidenced by the doubling of annual waste volume receipts at the Nash and Ross landfill over the past couple of years. So we will not be hard done by, or Nash and Ross will not be hard done by this proceeding. In my evidence, I'm also not disputing that Smooth Hill may be able to run in a manner that avoids attracting black-backed seagulls feeding or resting. I would, however, observe that the condition proposed by ORC regarding resident bird populations indicates that if there are failures in site management that attract gull populations, that the landfill will be rendered inoperable for what could be extended periods. or worse, that bird activity could cause significant damage or disruption to aircraft operating into and out of Dunedin International Airport. Reliance on avoidance strategies for minimising gull populations is a very high-risk strategy, particularly when there are clearly a range of low-risk alternatives that do not appear to have been fully considered in the consent application. The purpose of my statement of evidence is to illustrate that regardless of whether Smooth Hill is developed or not, there are workable and economically feasible alternatives to Smooth Hill for the disposal of waste that have the potential to attract feeding birds. Separating out the potentially problematic waste is not complicated, as the putrescible and non-putrescible waste tend to be generated and delivered separately, only being mixed at the landfill. Nash and Ross's landfill provides a clear example of this. It receives some 90,000 tonnes of waste annually, and any putrescible or compostable wastes are rejected at the landfill weighbridge. Nash and Ross also receives a further 20 tonnes of green waste, 20,000 tonnes of green waste at their associated green waste landfill, where it is processed with a shredder and composted for reuse. It is also clearly understood within the landfill clientele that only specific classes of waste may be disposed at this landfill. As I note in my evidence, the Nash and Ross landfill does not attract feeding gulls. That doesn't mean that gulls aren't present in the landfill environs, because gulls that feed at Green Island also cruise the wider area and appear to prefer to rest on the roofs of industrial buildings some distance from the landfill. And if I may make an aside too on the conversations just gone past, that seems to be something that's overlooked, and that 4 kilometres is nothing to a black-backed seagull. It's 2 flaps, he's airborne and he's down there. And from our observation of around Green Island and our landfill, or Nash Ross's landfill, is that the birds like to sit on tall buildings with flat roofs with a bunch of their mates, where they've got a good launching point to take off. And if you look at the environs of Smooth Hill, there aren't that many large flat roof buildings around. The Burnside landfill will never be able to accept putrescible wastes, which puts it in the same situation as Dial is proposing for the operation of Smooth Hill. The alternatives presented in my evidence are options that Nash and Ross themselves have considered when contemplating broadening the scope of their operations. I'd estimate that no more than 25% of the waste stream handled by DCC Green Island presently would require disposal at an alternative to Smooth Hill that was not within the 13k buffer zone around Dunedin International Airport. This volume equates to between 2 and 3 50-tonne loads daily during the working week. Waitaki District Council presently sends its domestic waste 300 kilometres to the Southland Regional Landfill as backloads on agricultural lime deliveries to Canterbury, and Nash and Ross receive waste from Christchurch also as backloads. So transporting waste over these distances is not difficult, unreasonably expensive or unduly carbon intensive, as it's utilising idle capacity and heavy vehicles already making the journey. These considerations are very important because landfilling provides an essential service to the city economy. Any disruption to landfill operations that may arise from a breach of the proposed condition requiring that all bird species in the bird management plan greater than 50 grams feeding at the landfill or accessing water bodies must be managed to 0 densities daily. If this is not achieved over 3 consecutive days, then the landfill operation must cease and material covered, including netting if necessary, until 0 densities of birds over 50 G can be reached over 5 consecutive days, will have a very significant flow-on effect through the economy, as waste generation has no buffering capacity. Waste is a flow, and any clogging of that flow will have significant consequences through the entire city economy. And so that's really summarising my evidence. I'm happy to take questions on the specific points that are covered in it and the statement of evidence. Thank you very much.
Thank you. Rose, any questions? And Jane, any questions?
I've just got one or two, nothing terribly much, because I do understand what you're saying. Just where you've been talking about the waste that's being trucked and backfilled and so on, has that got anything to do with disposal costs at various landfill facilities?
It is, yes, and that Waitaki's clearly getting a competitive price because their alternative is to go to Redruth and Timaru, which is only 100 kilometres away. So they're obviously getting a better price from the Southland Regional Landfill than they are from a much closer landfill. And similarly, we get a lot of shredder flock, which is waste from the recycling of metal waste such as cars and fridges and whatever, whiteware, from Canterbury because there's two constraints in going to Cape Valley. One is the per tonne cost, the other one is that they have to take it in specialised vehicles. Whereas at the landfill down here, we can accept it in their 50 tonners, which are carting scrap from Southland and Otago back up to Canterbury for processing. So again, they're bringing it down as a backload, so their cartage costs are virtually nil.
The one thing I've never really got my head around in all of my years of being involved in this industry as a legal person is where are the highest profits derived from in a landfill? What sort of waste brings in the most gold?
It would be probably difficult to say. I mean, I think it just seems to be rolling in at the moment. waste is money. I think it's better to look at where the costs are, and the putrescible wastes are the expensive ones to manage. All of the demolition and contaminated soil wastes that we receive are handled pretty much the same way, and in actual fact don't require a lot of care in their disposal because they're relatively inert. The waste stream that we would accept that's the most expensive to manage are asbestos contaminated wastes, which need buried in a separate cell and covered immediately. But the rest of it is inert. It doesn't generate any significant discharges. We don't have a gas issue. And this is one of the problems you have with setting up a landfill such as Smooth Hill, where domestic waste, which are putrescible, are going into it, is that it actually converts the entire waste stream to having to be managed as the most problematic component of the waste stream. And to me, it actually seems to be really illogical in that the Nash and Ross landfill, which is handling the same sort of waste volumes as Smooth Hill is proposed to, generates about 5 litres of leachate a minute. That is actually at 1% of the trade waste criteria for discharge to the sewer. We've got access to the sewer, so it's a fully contained landfill with a sewage discharge. And as I say, we do gas analysis on it all the time. We don't need a gas collection system because there is no gas generation. So there's a whole lot of things that keeping putrescibles out of your waste stream make very cheap and straightforward. And this is one of the things that we see with Smooth Hill, is that Nash and Ross have got such a low operating overhead compared to what Smooth Hill will have, that's why we say we can't see it being an economic disadvantage to the operation.
Have you been tuning in to the hearing before you appeared today?
No, I haven't.
No? I've asked quite a lot of questions around the practicality of separating out the putrescible waste, how that's done at the transfer station, how you try and assure yourself that you don't have more than whatever your goal is. In this case, it's about 5 to 10%. So what's the story at Nash and Ross's landfill? How do they manage their non-acceptance of putrescible waste? How do you know?
It goes over the weighbridge. I mean, if someone turns up with, and it's an understood across the industry, we have had the odd case where someone's trying to slip something in, but it turns up as soon as it's dumped off the truck, the guys at the tip head see it, and they're on the phone straight away, and the guys get hauled back to take it away.
Right. So is it
there are small? We actually have also some of the staff. There are some small skips up there. So if we get small components that are problematic, they go into a skip and then they're taken across to Green Island. And you know, probably the advantage of this operation is we can afford to be picky. The city is stuck with sort of the responsibility of actually taking all of the wastes. The Burnside landfill doesn't have to, so it can offload that stuff. But it does go back to the thing is that they are still separate waste streams until they get mixed in the larger part. You know, the household wastes can be sorted. The 4-bin approach is going to facilitate that greatly, I would think. And for the industrial ones, they are clearly identifiable. They come away as an entirely separate load, and they usually are screamingly obvious. Like if someone pulls up outside your weighbridge office with a load of putrescibles, they don't even need to lift the cover off it to spot it. And so, yeah, just it's not a problem.
Right, so the applicant is proposing that its landfill is not really going to accept much putrescible waste. I mean, we're talking about quite minimal amounts from what the evidence that's been given. And the airport seems to be concerned about the sort of special contaminated waste, special loads, that sort of thing, wants that out. So I'm just getting a little confused in terms of the message I'm getting from the airport case at the moment, because you're basically saying you can easily take it out, it's not a problem, doesn't end up in the landfill. It's pretty much what the applicant told us yesterday.
Well, I don't think we're quite getting that in the application, is that they're still talking of taking them but actually processing them with care so that they don't attract birds. Now, I couldn't comment on whether that would be successful or not.
Why would it not be successful if
your
landfill's doing it?
It's clearly not happening at Green Island at the moment.
Sorry, Mr. Keogh, when the Commissioner's asking you a question, can you wait for the question to be finished before you pop in with what you think the answer might be to a question that you haven't heard yet?
We're not allowed to have a discussion as such. You can't ask me questions. So what I'm trying to get my head around is if it's sort of working at Nash and Ross's landfill, if it doesn't take putrescible waste, why would it not be a problem at this landfill? We're not talking about Green Island because there's a whole different process proposed here. So why is that an issue?
If they don't accept putrescible waste at Smooth Hill, I can't see why they would have any more issues or less issues than we have at Burnside.
Right. And the discussions have been around there might be a bit of putrescible waste that gets in because there's always that chance. That's going to be the same for Nash and Ross, isn't it? You're not all going to be able to just say zero, because there's always a risk it will get in.
We aim for zero. As soon as we get putrescibles in there, we get compliance issues without consent.
Yeah, but I think everybody aims for zero. It's just a question of whether you can always guarantee it. So the answer, I think, is no.
We're pretty close to no.
Yeah, okay. That's all I've got for you. Thank you. I just wanted to get my head around that. Thanks.
Mr. Keogh, in your statement of evidence at your paragraph 7, you say you agree to comply with the expert witness code of conduct. So I assume you're appearing before us today as an expert.
I think so, yes. I've had a fair bit to do with landfills over my years.
Yes, so what is your area of expertise that you're appearing before us today?
Well, my current company does all of the consenting and environmental monitoring for Burnside landfill. In my earlier days, I was a partner in a landscape and planning consultancy, and we partook of we were a contributor to the assessments for the current operating consents for Green Island, for the original site assessment at Smooth Hill. We also were engaged in and we were only doing the landscape and planning and aspects of it, but we were fully sort of involved with the thing. For the Southland Regional Landfill, but not the current operating one, there were some other options they looked at. And as a CEO of a council, I've been in charge of the operation of landfill, so I'm sort of well versed in the practicalities of it. We've done all the consenting for the current operation at Burnside. One of my employees has a PhD in biochemistry and has 25 years experience in the management of digesters and waste treatment plants, so we're reasonably well informed.
I'm not interested in the qualifications of your employees. So are you coming before us today as a technical witness or an evaluative witness? Do you understand the difference?
Yeah, well, I'd say both.
Both.
And that, as I say, we are well versed in applying for consents for landfills, and we are well versed, and I participate in the environmental monitoring of the landfill. But also I have a background in management that, I've actually been operating as a CEO of a local authority where, landfill operations are part of our activities.
Yeah, okay. Well, thank you, Mr. Keogh. I have no further questions for you, the reasons being that your evidence talks about alternatives for trucking waste out of the district and incinerating the waste, both of which I think the City Council's considered and dismissed, and Te Runanga opposes based on the evidence of Edward Allison. So I don't need to ask you any more about that. And the remainder of your evidence seems to promote the merits of the Nash and Ross Landfill, which you're affiliated to, and I think in your presentation you've referred it to, it is our landfill, so no further questions, thank you.
It's now time to see if we can find Mr. Bonas online.
Hello panel, can you hear me?
Good afternoon, Mr. Bonas, we can hear you and see you.
Excellent.
Well, we can see half of your head anyway.
Yes, I have a face for radio. Good afternoon panel. You'll be pleased to know that I don't have a summary to take you through. What I do have is I've listened to Mr. Shaw and also Mr. Dale, and I just wish to reiterate or go through a couple of points in terms of the discussion that they had with the panel, which may alleviate, I guess, the possibility of some of the questions.
Sorry, Mr. Bonas, if I could just stop you there. Mr. Page, did you want to have Mr. Bonas address anything first before you're just happy for him to go?
No, I'm happy for him to proceed as he is, if that's okay with you.
Oh, absolutely okay with me. Just he jumped in. I wasn't sure if you wanted to direct him at all. Mr. Bonas, carry on.
Thank you, sir. Sir, as identified in paragraph 10 of my evidence, I've relied on the evidence of Mr. Shaw. He is the aviation risk expert that's available to the panel. The differing opinions with Mr. Dale effectively are as he's identified. It's the interpretation of that evidence. And I guess a lot of that sort of turns on that in terms of the recommendations that I've provided for the panel in terms of Dunedin Airport. And really it boils down to three major points. And one is the confidence, the calibration, and the certainty that these matters are actually contained within the assessment of Mr. Dale and then embedded coherently within the conditions. And Mr. Page has identified that there's been some toing and froing from both DIL, myself, Mr. Shaw and Mr. Dale in that respect. Criteria 2 is really sort of the long-term reliance on those conditions. There's a 40-year, I understand, a 40-year time period associated with the landfill. So it's the ability to rely on the implementation and confidence of those conditions over the long term. My understanding in reading through some of the initial assessment done by Boff and Miskel was, and Mr. Shaw pretty much reiterated it yesterday, what I understand we're trying to prevent through the conditions is a pattern of behaviour establishing. Because once the pattern of behaviour is established, it's far more difficult and far more costly for the consent holder to then disrupt and disperse that condition. And consequently, where those two first criteria flow to is the manner in which the statutory framework then applies. So fundamentally, Mr. Dale and I probably aren't too far apart. Mr. Shaw has provided his expert view. He's working with him previously as I have at Christchurch. He's a very optimistic man, but he's an expert. And he relies on the planners to say, yes, these are how your matters are then rectified and installed within the conditions. And I think that's largely where myself and Mr. Dale perhaps depart. In terms of listening to Mr. Shaw yesterday, in terms of matters of agreement, I understand that there's now agreement that DIL has a high aviation risk that's already present, that no increase in risk is acceptable, and that without mitigation, and these are my words in brackets, and I suggest that such mitigation needs to be both clear and certain, then there is an unacceptable risk to aviation. Those were some of the themes that I got from Mr. Shaw's evidence, and he reiterated that to the panel yesterday. He did talk about a relativity risk at Dunedin International Airport, fairly or unfairly. But sir, in my view, the difference being that DIL can actually undertake actions to manage that issue under its wildlife hazard management plan within the property that it has controls over. It can't control risk at Smooth Hill. And CAA's only lever, as I understand it, is, in terms of issues at Smooth Hill, is to constrain Dunedin International Airport. So, fairly or unfairly, there was a couple of pot shots in terms of relativity. In terms of weighting, sir, there was a discussion had between yourself and Mr. Dale this morning. I agree with Mr Dale and also yourself in terms of weighting. Substantial weighting is to be applied to the partially operative Otago Regional Policy Statement, with little weight to the proposed Otago Regional Policy Statement, given where it is in the process and the large number of submissions. Not a lot actually probably turns on that panel. There's very little light in terms of the way that the infrastructure provisions are treated between those two frameworks. I would turn your attention to policy EIT-INF P15, protecting infrastructure within the proposed regional policy statement. And that deals with this issue, I think, that we're all sort of working our heads around now in terms of the issue between sort of reverse sensitivity and significant effects on nationally and regionally significant infrastructure. And that particular policy actually covers off them both coherently. It talks about avoiding establishment of activities that may result in reverse sensitivity on such infrastructure or may otherwise compromise the functional or operational needs. So it covers both. In terms of incompatibility versus reverse sensitivity, which is, I guess, at the front of mind in terms of the interpretation of policy 4.3.58, there are lawyers in the room that are far better equipped and should be providing case law to the panel on this matter. My understanding is that it sort of treads back to the Winston Aggregates case, and essentially the premise is the effect on existing lawful activities from the introduction of new activities or the intensification of existing activities in the same environment that may lead to restrictions on existing lawful activities as a consequence of complaints. As I've noted in paragraph 23 of my evidence, where the CAA seeks that DIAL reduce aviation activities, now that in my view represents a conflict with policy 4.3.58 in terms of reverse sensitivity. It's the incompatibility is the conflict with the plane. The landfill is not in and of itself sensitive to an airport, but the consequences of what happens as a result of that in the CAA using its only lever, in my view, would go into that. But I agree with the panel discussions with Mr Page. It's not particularly clear cut. And I would turn to policy 435 of the operative regional policy statement, where either of those sort of three preceding limits are sufficient in terms of focusing the panel's attention. With A obviously being restricting establishment that may result in reverse sensitivity effects, and the may probably being the key phrase there. B being avoiding significant adverse effects on the functional needs of such infrastructure. And there appears to be agreement by all the witnesses that unless mitigation gets to a certain point, that is the issue that we're dealing with. And clause C is avoiding, remedying or mitigating other adverse effects on the functional needs of such infrastructure. Just lastly, in terms of conditions, I'm very happy to assist Mr Dale or anyone else as directed by the panel. I note and reiterate the point raised by Mr Page that Appendix 3 doesn't in and of itself constitute a condition, and the 10% putrescible waste limit, it's not clear what its metric is, whether it's by volume or weight. Also, I have no understanding of the volumetric or frequency of highly odorous waste to be accepted in terms of condition 43F. And in terms of Green Island, there's considerable discussion in the evidence for the applicant as to the importance of the managing bird activity, bird numbers, prior to that facility closing down. There's very little in terms of the conditions or the details as to how that could be undertaken, the vagaries of it. I acknowledge and agree, sir, with the comment around the Augier condition in terms of how a package for that could be undertaken. But I do note that Mr Shaw responded yesterday to the panel that he was of the view that the adaptive management would be enough, regardless of what actions were taken when Green Hills facility was starting to close. I was somewhat surprised by that. There is sufficient material within both his evidence and also the preliminary bird hazard assessment undertaken in conjunction with Boffa Miskel, that was a key plank in terms of reducing potential aviation risk from birds to Dunedin International Airport. I hope that's relatively clear, sir. I'm happy to answer any questions.
Yeah, thank you, Mr. Barnes. I see we have questions for you. Last questions?
Good afternoon. I can't help myself but go back to this reverse sensitivity issue.
Yes.
Thank you. So I just want to check that I've understood what you've said today, because you did cover quite a lot in your verbal submission then. So can you just take me through your understanding of reverse sensitivity again? You
sure.
kind of had a definition there that you...
So the definition that I referred to is my understanding of sort of what came out of the original sort of Winston aggregates case. And it really was around where sensitive activities move in proximity to something else that has been lawfully established. And then as a consequence of incompatibilities, raise complaints that then lead to restrictions in terms of functions, operation of the initial existing facility. The issue we have in this particular instance is that I think I agree with Mr. Dale. The landfill in and of itself doesn't take us directly to a reverse sensitivity effect. It's not sensitive to planes coming and going at the airport. We're kind of operating in the sort of middle area. But we are, as a consequence of the landfill operating, there are actual potential effects in terms of bird strike risk on Dunedin International Airport that leads to CAA using its own lever, and it has no ability to control what happens at Smooth Hill. It effectively would use that lever to limit or impose restrictions on Dunedin International Airport. Then that, in my view, takes us into the sort of principle of reverse sensitivity.
Sure.
It's highly unusual.
Yes, that's fine, that's great. I just wanted to check the definition that the example that you provided, because typically, of course, it's usually the effects of the established use and the adverse effects of those on the sensitive activity that's moved in to the environment that's focused on. So I've just been interested in to see everyone's, particularly the planning perspectives on that, and we've asked the consenting officers to look at that too.
Yes, I've also had some discussions with the Selwyn District Council hearings over the same issue, where there's clearly an incompatibility, but reverse sensitivity may not be sufficient to cover off all the grey, as it were.
Yes, and so what I'm hearing is that, and with regard to that key policy, which you do lean on quite heavily in your evidence, that first clause A is not quite as clear-cut as it might be in other circumstances, that we've got a bit of a grey area here, and we've got a situation where it might not technically be reverse sensitivity, but there are consequential impacts which could relate to incompatibility.
Just to add to that, I think I would put forward a planning argument that it's not an orthodox case of reverse sensitivity in terms of how that's perhaps considered. But I don't think that necessarily takes us away from the application in terms of that particular policy limb. But regardless, I think that there's clearly an incompatibility, and that takes us to the other limbs, which, as I've identified in my evidence, all of the limbs need to be considered and applied.
Thank you. Right, my other question for you, you've answered quite a few questions that I had prepared, but one that did strike me as I was reading your evidence is that while I appreciate that you were asked to do a narrowly focused assessment for the purposes of bird strike, when you're undertaking a planning assessment, I guess, to what extent did you consider any cultural considerations? You've talked here around, in some of your evidence, you've explored the matter of alternatives, and you've stated that you understand it from the Section 42A report that export of waste was determined to be viable. And I just wondered whether you had accounted for any cultural considerations in terms of the applicant's case, and any view you might have on that. From
a pure planning perspective, there are two limbs to that. One is identified in my evidence. I've taken a very, very narrow view, and it's just simply the implication of what I've got in front of me and the issue that I've been asked to consider. So I haven't gone into the broader, unlike yourselves, 1,500 pages of material accompanying this application. But I have a broad overview of all of that. Neither am I an expert in cultural values, similar to not being an expert in terms of aviation bird risk. That advice to the panel, quite rightly, will have to come from someone else.
Sure, I appreciate that. I guess just as a planner, I mean, we have to be pretty careful with our role in terms of arriving at overview conclusions, and it's always interesting to see exactly what we've factored into account when we're reaching that overview. I think that's an important thing to note. And so even though you might not be an expert in cultural values, it's still of relevance in your conclusion around the export of waste, I guess is what I'm exploring. And I don't know that I need to take that any further. I was just interested to hear how you'd approach that. Thank you.
Sure. The simple answer is I haven't factored it in. Yeah. So if the panel comes to the conclusion that culturally the migration of waste outside of the takiwā is inappropriate, then quite rightly that's where they should lead.
Thank you. That's all for me.
Jan?
No questions, thanks.
Thank you, Mr. Bonus. And I just wonder how forensic and concerned we need to get about the particulars of the policy provisions that we seem to have been spending a bit of time on. I mean, under Section 104, of course, we have to have regard to those provisions, and we know what that means. We can consider them and, if necessary, put them to one side if the merits of the case so dictate. But that's not what I'm suggesting here, but isn't it fairly simple? The only qualified bird strike evidence we have before us is from Mr. Shaw.
Yes.
His evidence to us, in very clear terms, is that any exacerbation of the existing bird strike risk at Dunedin Airport must be avoided. Now, I don't know how it can get any simpler than that in terms of the matters that we need to consider, without getting forensic about what is and what isn't meant by the various policy provisions.
I agree, sir, and that's why I started off my summary to the panel this afternoon, simply identifying where I diverged from Mr. Dale in terms of that exact evidence. So I agree entirely.
Thank you very much. All right, and now I look forward to and you've indicated you're happy to assist with any kind of condition drafting that various parties might need to undertake, and in this case I'd be particularly grateful of your assistance in that matter I raised with Council for the applicant regarding some kind of condition precedent that may be able to satisfy the concerns of Mr. Rogers and the CAA in terms of what would need to happen to get him to a position of comfort. Now, I don't know if that's possible or not, but I'd appreciate if your approach just to put your mind to that.
Will do.
Great, but no further questions, thank you.
Thank you all.
Oh, yeah, no, that's good. Got one more thing, but it's not for you, he's gone anyway, good. So, Mr. Page, just before you do your summing up or whatever you wanted to say by way of conclusion, just before I forget something, we'd be very keen to receive a write-up of the verbal presentations given to us by Mr. Rogers and by Mr. Bonus, not in terms of answering our questions, but what they said to us of their own volition before we got to questions, if you're happy to ask them to do that.
Well, the simplest thing for me to do would be to have the recording transcribed, and so that's what I'll do.
Yeah, that'd be good.
Just asking because it came pretty thick and fast.
Yes.
We're trying to write it all down, but I'm sure I've missed quite a bit of it, really.
Yeah, well,
so, but I don't, it's important that we have an accurate record of it.
Yes.
Because there was quite a bit there.
That's right. Helpfully, the Regional Council is posting the recordings online, and so I'll be able to have a transcription of that done, reviewed by the witnesses and then sent to you once it's been approved.
Yep. And maybe you could extend that to your own verbal presentation.
Yes.
That would be
happy
helpful.
to do that.
Yeah.
Thank you.
All right, so now back to you.
Well, I don't have anything else to say. You've got a clear grasp of what Dial's concerns are.
Sure.
we've got nothing else to add to that, other than to wish you the very best with your deliberations.
Thank you.
Thank you.
All right, so that's the end of today's proceedings. So just before I adjourn for the day, I'll ask my normal procedural question. Anything from the reporting officers team? Applicant, anything you want to draw to our attention at this stage? All right, so because we've gone quicker than we anticipated when the schedule was drafted, there's no hearing tomorrow. We reconvene on Friday with the publicised schedule of appearances. So we'll see any of you who are keen to carry on participating on Friday.
Thank you.